Good morning, everyone. Welcome to this meeting of the California Privacy Protection Agency Board. It is April 4th at 8:39 a.m. I'm the chairperson of the board, and my name is Jennifer Urban. I'm pleased to be here in person with the board and some members of the public, and to welcome many of you on Zoom. Before we get started with the substance of the meeting, I will have some logistical announcements, but most of those I will leave for a little bit later, which I'll explain in a moment. For now, I'd like to ask everyone to please make sure that your microphone is muted when you are not speaking. And if anyone's here in person has a cell phone, to turn it off or silence it to avoid interruption. Third, and importantly, this meeting is being recorded. Thank you very much. The meeting will follow the Bagley-Keene Open Meeting Act, which is required by law. We will proceed with the topics on the agenda. That's available as a handout here in San Francisco and also on the CPPA website. Meeting materials are also available both in handouts and online. Please note two things regarding the agenda for today. First, we have been taking the item for public comment regarding items not on the agenda early in the meeting. However, today we have only one major agenda item on a major topic today. That is agenda item number 3. And I anticipate that most attendees will want to comment on that item. Accordingly, we are going to go straight into that discussion before we do the general public comment item, and that will be number 4. Second, today's agenda includes a closed session item. It's listed as number 6, discussion of possible action, and possible action on the appointment of an executive director and chief privacy auditor under authority of Government Code 1126, subdivision A1. We'll be taking that item first at the top of the meeting, and once we finish our closed session discussion, we will return to this public session and continue with agenda item number 2. I will provide the usual instructions regarding participating in the hybrid meeting when we return, rather than to ask everyone to remember those details while the board is in closed session. We appreciate the CPUC team for their hospitality and for allowing us to use their boardroom and providing AV assistance for today. So thank you very much. And with that, the board will go into closed session and we will be back in a bit. Thank you. Welcome back, everyone. Well, welcome back to the board, and welcome back if folks stepped away while we were in closed session. The CPPA board is now returning to open session, and we'll proceed with the agenda. I promise, and I'm sure you're thrilled and excited to talk about meeting logistics at this point. So let me go ahead and do that. As a reminder, the agenda and meeting materials are available as handouts in San Francisco and also on the CPPA website. You may notice board members accessing their laptops, phones, and other devices during the meeting. This is, they're accessing their devices solely to access the board meeting materials and what is needed for the meeting. After each agenda item, there will be an opportunity for questions and discussion by board members. I will also ask for public comment for each agenda item. This meeting is taking place in a hybrid format, and you are welcome to comment in person here at the California Public Utilities Commission or via Zoom. Each speaker will be limited to 3 minutes per agenda item. We do have a designated item for general public comment on items not on the agenda, and that is agenda item number 4 today. If anyone hasn't joined us for a while, we had been scheduling that more at the top of the meeting, so to help people predict. But because we only have the one major topic on our agenda for today, number 3, we want to be sure we have plenty of time for board discussion and for public comment, which we anticipate will mostly relate to that agenda item. So we will just take the general public comment as item number 4. If you're attending via Zoom and you wish to speak on an item, please wait until I call for public comment on the item and allow staff to prepare for Zoom public comment. Then you can use the raise your hand function, which is at the bottom of your screen. And if you wish to speak on an item and you're joining by phone, you can press *9 on your phone, and that will show the moderator that you are raising your hand. Our moderator will call your name when it is your turn, request that you unmute yourself for comment at that time. Those using the webinar can use the unmute feature, and those dialing in by phone can press *6 to unmute. When your comment is completed, the moderator will mute you. Please also note that the board will not be able to see you, will only be able to hear your voice. This is helpful if you identify yourself, but this is entirely voluntary, and you can input a pseudonym when you log into the meeting via Zoom. If you're attending in person and wish to speak on an item, please wait for me to call for public comment and then move towards the podium to my left and form a line. And you will be called to the podium to speak in your turn. As with the Zoom attendees, it's helpful if you identify yourself, but it's entirely voluntary, and you're free to refer to yourself with a pseudonym or not give a name. Please speak into the microphone so everyone participating remotely can hear you, and also so your remarks can be recorded for the meeting record. The hybrid format does make our meetings much more accessible to the public. It also creates technical complexities. So if we have technical kinks, we will pause the meeting to address the issue. I'd like to again thank the CPUC team for managing the technical aspects of the meeting today. I know it's a complex task. And second, I will explain what to do if those attending remotely experience an issue with the remote meeting. For example, the audio dropping, the video dropping. If something happens, please email info@cppa.ca.gov. That's N for Nancy, F for Frank, O@cppa.ca.gov, and this will be monitored throughout the meeting. If there is an issue that affects the remote meeting, we'll pause it so that staff can fix it. The board welcomes public comment on any item on the agenda, and it is always our intent to ask for public comment before we vote on an agenda item. If for some reason I forget to ask for public comment and you wish to speak on that item, please let me know or let us know by using the raise your hand function, or if you're here in person, you can wave at me, and you will be recognized. Once again, each speaker will be limited to 3 minutes per agenda item for public comments. Related to that, I would like to remind everyone of the meeting parameters, discussion and comment parameters imposed by the Bagley-Keene Open Meeting Act. Both board members and members of the public may discuss agendized items only. And when speaking on an agenda item, both board members and members of the public must contain their comments to that agenda item. There is one exception, which is that the public can bring up additional topics when the board gets to agenda item 4 today, which is specifically for members of the public if they would like to bring up topics not on the agenda. On that item, though board members cannot respond, we can only listen. Today's board meeting is held at the California Public Utilities Commission in San Francisco and on Zoom. We appreciate the CPUC team for their hospitality. We will take breaks as needed today, including one for lunch. I will announce each break, and if I can, when we plan to return, to give folks in the public the opportunity to leave and come back if they wish. My thanks to the board members for their service and to all the people working to make the meeting possible. I'd like to thank the team supporting us today, Mr. Francisco Hernandez and the team of conference services experts here I mentioned. For the CPPA, I'd like to thank Mr. Philip Laird, who's acting as our meeting counsel, and for all the staff who will be presenting to us today. And I'd like to thank and welcome our moderator, Ms. Serena Marzian, and ask her to please conduct the roll call.
Thank you, Board Chair. Board Member Liebert.
Here.
Board Member McTaggart.
Aye.
Board Member Nanecki. Board Member Worth.
Here.
Chair Urban.
Here.
Madam Chair, you have 4 present members and 1 absent.
Thank you very much, Ms. Marzian. The board does have a quorum, and I would like to remind board members we'll take a roll call vote on any action items. With that, I will move to agenda item number 2, which is an update and introduction of our new executive director, Tom Kemp. As far as updates, there's been a public announcement of an enforcement action, and I'd like to commend the enforcement team for all of their diligent and thoughtful work to continue to build out the agency's enforcement arm. Our big piece of news connects to the other issue, though. The board made the decision to appoint Tom Kemp as the agency's new executive director, and we are very pleased to welcome him today. Tom has extensive background in privacy legislation, cybersecurity, and technology policy, and we are delighted to welcome him as a leader to guide the agency's work implementing the board's vision to protect California privacy rights. The board and staff, I hear, are excited to collaborate with Tom. Executive Director Kemp. I apologize. He's a friendly guy. To further the agency's mission of enforcing and implementing the state's comprehensive privacy laws. His leadership to implement the board's vision will be instrumental, and we are delighted to have him. Thank you, Tom. Executive Director Kemp. On behalf of the board, I would also like to express our sincere and deep gratitude to Ms. Tiffany Garcia for her stellar service as interim executive director during the transition period. Her leadership, her dedication, and her exceptional skills have been invaluable during this transitional period. Additionally, we extend our appreciation to Tamara Coulson, who's our CPPA Assistant Chief Counsel, and Milad Dalju from the Attorney General's Office for their assistance throughout the executive director search process. So thank you, everyone, for all the work, and thank you, Executive Director Kemp, for joining us. Are there comments or questions from the board? Yes, yes, please.
I just want to second the point that you made about staff and particularly Tamara and of course Tiffany, who jumped in. And Tiffany, thank you so much for your patience this last number of weeks or months or years. I don't know how long it's been, but you've done just an absolutely fantastic job, and I know the board really appreciates all that hard work.
Thank you very much, Mr. Lieber. Any other questions or comments? Yes, Mr. McTaggart.
Yes, well, thank you, Tiffany, so much for your excellent service in the interim, and congratulations to Mr. Kemp for his appointment. Looking forward to working with him. Thanks.
Great, thank you. Mr. Wirth.
I have to say something now, right? I just repeat and the appreciation for what you've done and what you're going to do.
Thank you, Mr. Wirth. With that, we move to agenda item number 3, discussion and possible action on proposed regulations regarding automated decision-making technology, risk assessments, cybersecurity audits, insurance, and updates to existing regulations, including possible modification of the text, which will be presented by CPPA's General Counsel, Mr. Philip Laird, and attorneys from the legal division. I will turn it straight over to you, Mr. Laird, if that's all right. Oh, my goodness, I apologize. You know, I say if I forget to wave your hand, and in my defense, I almost never forget. So is there any public comment on item number 2, which is updates? I mentioned enforcement and introduction of the agency's new executive director, Mr. Tom Kemp.
This is for agenda item number 2. If you'd like to make a public comment at this time, please raise your hand by using the raise hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 2. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian, and to Mr. Laird for the reminder. With that, please do go ahead.
Thank you, Chair Urban, and welcome, Mr. Kemp. We're happy to have you here from staff level. So today's agenda item 3 regarding proposed regulations on automated decision-making technology, risk assessments, cybersecurity audits, insurance, and updates to existing regulations is really a long time coming to this discussion. As we know, this has been a sort of multi-year effort by this board, and sort of the formal rulemaking process commenced last year and opened officially in November with a public comment period that closed on February 19th. So today we're sort of at a big crossroad for this proposed regulations in terms of some opportunities for the board to weigh in and provide additional direction on potential modifications to this text. To facilitate today's discussion, staff is prepared to walk the board and the public through 6 high-priority issues that we've identified as needing some directional feedback from the board. That feedback then will drive potential modifications and changes that staff will make as we prepare a full set of proposed modifications, ideally for the next board meeting. We'll intend to pause after each issue is introduced, and we'll ask the board to discuss and decide on a path forward. I will do my best to summarize the board's decision on a given issue before moving on to the next one to ensure we're all sort of clear on what majority consensus is. The board could then send that set of revised proposed regulations out for another round of public comment. Again, under the Administrative Procedures Act, if we make modifications that are substantive at all, we do then have to open them up for another round of public comment for feedback on those modifications. So moving on, if we can, to slide number 2. So we've included this slide to reorient the public regarding the rulemaking process and our current status, which is circled in red on the slide. So as I mentioned, comment period opened November 22nd, 2024, and was open until February 19th, 2025. The agency received 630 comment submissions. This includes over 1,664 pages of written comments, as well as oral comments provided during the formal comment period. There were a total of 626 unique commenters. Approximately 431 of those comments were part of a letter writing campaign, we believe, from consumers to support the agency's draft ADMT regulations. And then there were additional 9 comments from consumers sort of outside of that letter writing campaign. Approximately 165 comments came from industry, trade groups, or similar organizations, and 13 comments from civil society organizations, such as consumer advocacy groups. Really, from the bottom of our heart, at least, at the staff level, we'd love to thank all the commenters for participating in the 45-day plus public comment period. We really received super thoughtful, helpful, informative comments that have helped us consider ways to both strengthen and streamline the proposed regulations. And I just want to emphasize, this is the Administrative Procedures Act at work. This is exactly how it was intended to operate, and we really appreciate those that are engaging this process along with this agency. We're at the stage that's circled in red on the slide. Staff are processing and considering comments received and are raising issues for the board. So in terms of where we go from here, as I think the board is aware, we have until November 2025 to finalize regulations for submission to the Office of Administrative Law. Finalizing the regulations means submitting the final rulemaking package along with all the required accompanying materials that the agency must prepare, such as a final statement of reasons, as well as responses to all the public comments received in this last public comment period, as well as any other future public comment periods that we engage in over the coming months. In order to meet our November deadline, we at staff level are recommending that the board provide staff with feedback on its preferred approach for each of the issues teed up for discussion today. And with that, then we would intend to implement that feedback from today's meeting and propose additional revisions to the text based on public comments received for the board's upcoming meeting in May. At that point, the board would have another opportunity to review sort of all of those proposed modifications. And then, again, we would begin an additional public comment period for the public to engage in. One point of clarification here on this slide, I know for those looking at the sort of buckets of possibilities, there's this differentiation between major changes or substantial and sufficiently related changes. To make this perfectly clear, everything we're discussing today would fall into that latter bucket of substantial and sufficiently related. Major changes is a bit of a misnomer. Essentially, it's only changes that were not foreseeable at all based on the initial proposed text that would sort of necessitate an additional 45-day public comment period. We're not in that world here, so we really are talking about substantial, potentially very substantial changes, but still sufficiently related to the topics in the original notice of these regulations. With that said, I just want to note too, when we encourage this timeline and to hopefully get some modified text out for the public to consider and give us feedback on, again, coming out of our May board meeting, that would allow a few things, including if the board was so inclined, an additional public comment period if necessary before November, or early submission in advance of November. But we still have 6 months to kind of work through this process and to try to get these regulations in the best shape possible. And so the stage, again, we're at today is we're now ready to kind of talk about what changes we might see from those original proposed text. Okay, so enough from me. At this point, I'm going to be turning things over to my esteemed staff and colleagues here in the Legal Division, Lisa Kim, Kristen Anderson, and Nilüfer Sheikh. Take it away.
To slide 3, please. Thanks. The 6 issues that we've teed up for the board's discussion today are modifying the definition of automated decision-making technology, modifying the definition of significant decision, the behavioral advertising threshold, the work or educational profiling and public profiling thresholds, the training threshold, and submissions of risk assessment materials to the agency. As our general counsel mentioned, the intention for today's meeting is to address the issues one at a time. So we'll provide a brief introduction to each and then pause for the board's discussion before proceeding to the next. As a general note, the potential alternatives in the presentation are just based upon public comments and intended to facilitate the board's discussion, but they're not exhaustive. Next slide, please. Before we dive into the specific issues, we're providing this chart as a refresher, which provides a summary of the requirements for businesses' uses of ADMT under the currently proposed regulations. Many of the items on the slide are issues for discussion today. That includes the definitions of ADMT and significant decision, the extensive profiling thresholds, and the training uses of ADMT. These are all at issue. So we're displaying the slide to do 3 things. First, to remind everyone of the ADMT framework in the currently proposed regs. Second, to highlight the issues before the board today. And third, to illustrate how certain decisions the board makes today would impact businesses' obligations and consumers' rights. Next slide, please. So first, we're turning to the definition of ADMT. This slide presents a shortened version of the definition from the proposed regulations. As you all know, CCPA directs the agency to issue regulations governing access and opt-out rights with respect to businesses' use of ADMT. But CCPA does not define ADMT, so the agency has to define the term to clarify for businesses and consumers the types of technologies that are subject to regulation. I'll note here again that the definition on its own does not mean that the business has any obligations with respect to its use of ADMT. Rather, it's the business's use of ADMT in one of the ways set forth in the thresholds that triggers the obligation. We received many public comments about the definition of ADMT, but there was no clear consensus on how we should modify the definition. Public comments range from requests to broaden it, to support for the existing regulations, to narrowing the definition. Civil society organizations recommend using the definition of automated decision systems from the California State Administrative Manual, which is also in the government code. That would broaden the definition to reach technology that assists decision-making. Industry commenters, on the other hand, commonly recommend narrowing to solely automated technology used to make significant decisions or decisions with legal or similarly significant effects. And then finally, many comments, especially as part of the letter writing campaign from consumers, generally support the proposed ADMT regulations as currently drafted. Next slide, please. Based upon the comments, we prepared 3 alternatives to facilitate the board's discussion. Alternative 1 would reflect feedback we received from comments to broaden the definition to cover decision-making that even just assists human decision-making without a qualifier, to the extent that the decision materially impacts consumers. It would also align with how the California Government Code has defined the automated decision systems. We made minor modifications to the Government Code definition just to conform to what CCPA covers. Specifically, we added the concept of processing personal information, and we replaced the term natural persons with consumers. For alternative 1, we will note that our regulations would have to clarify what, quote, materially impacts consumers would mean. And that's, again, because our regulations need to meet APA clarity requirements. Therefore, if the board prefers alternative 1, staff would need directional feedback on which, quote, material impacts the board would want to regulate. Alternative 2 would reflect feedback we've received from comments to narrow the definition to more closely align with other privacy regimes, such as GDPR and Colorado. This alternative definition leverages concepts from both while providing additional clarity to meet APA clarity requirements. The alternative would also delete the concept of executing a decision, but this wouldn't be a substantive narrowing because replacing human decision-making would also cover the concept of technology that both makes and executes a decision. Finally, alternative 3 would reflect comments we've received from businesses and trade groups to narrow the definition so that it applies to solely automated significant decisions made without human oversight. Now, with that, we've provided the overview of the alternative definitions for the board, and we'll pause for the board's discussion of these alternatives.
Thank you very much. First, I just want to thank the staff for their incredible work on this throughout and in digesting 16-something hundred pages of comments for us. I may need to pause from time to time because I have to find something in a comment, and I apologize in advance if that's the case, because it is such a substantial record, and the practicality and the care with which the legal division team has approached this process and has approached the comments and advising the board or giving the board alternatives is simply extraordinary. It is some of the best lawyering I've ever seen, and I've been a lawyer a long time, and I really greatly appreciate it. I also want to express my gratitude for the public comments as well. I know staff are very grateful. I'm extremely grateful. I do want to be clear that I'm not sure counting them is always the best picture. Because one of the things I appreciated, and when I've talked to groups of interested parties and lawyers, et cetera, I always ask for a couple things, and in comments, and one of them is to be quite specific, please, about how something would affect you. And then if you can give us language to consider, please do it. And there are a number of comments that did that. And I know it was a lot of work, and I greatly appreciate it. And the second thing is, we don't need 50 comments if you're able to align. And so, for example, there's a comment from 56 labor and consumer groups, or labor and civil liberties groups, and they took the time to align and then to send in a comment, and that is very appreciated as well. None of that is to say that I would have liked all the consumers to do that, because consumer comments have a different kind of value, which is telling us about the real world as experienced by people, and this is obviously crucially important. It needs to underpin everything we do, and I greatly appreciate the time that everybody took to write in. So thank you to the staff and to the public, frankly, for all the work to help us get this right. I had a question about the 3 modifications. Which is, well, actually, you know what, I will hold my question because it's really actually related to a next step as opposed to the ADMT technology. So I will ask if the board have other questions or comments. Yes, please, Mr. Wirth.
Yeah, I echo what you said, Chair, about all the effort you all made. I think if you go back to when we voted to take this step, I think one of the things that the prior board member, Lay, and I both discussed is we need to get this out to the public. We need to get, I have the binder here of the 626 unique comments. No? Show it to them.
Yeah, pick it out. No.
So we never find what So we appreciate it. I want to say there was a period where I think I got the same exact email every day for about 60 days. That's probably not the most effective way to communicate concerns. I think that, anytime someone can show up here in public so we can engage in a conversation, it's going to be so much more fruitful. But I really appreciate the effort that we all took. I'm ready to jump. One of the things I'd love to do in the future is put page numbers on so I can remember where we are. But, I have a question regarding, unless someone wants to talk more general first, but we'll jump into this after that.
Okay, Mr. McTaggart.
Thanks. Yeah, I do have a general comment. Well, first of all, yeah, thank you all for a tremendous amount of work going through all these documents. It just was a mountain of work, but also amazing outpouring of feedback from all viewpoints on these regulations, which is obviously what we wanted to do. And so, before we get into the minutia and attempt again to wordsmith in real time various regulations, I'd like us to step back a bit and remind ourselves of where we are, how we got here, and ultimately I want to make a motion. So I'm against us getting right back into the weeds of specific language rewrites when I think we're ignoring the big picture around these proposed regulations. So for well over a year, an inordinate amount of staff time, just an enormous amount, has been spent on two relatively tiny clauses in a 56-page bill. Yes, they're important. They seek to regulate the areas of cybersecurity, risk assessment, and automated decision-making technology. But there are also 3 paragraphs in a 56-page bill. And every time I've objected, and as regular listeners will know, I've been objecting for well over a year, staff and some other board members have assured me that we just need to clear the next hurdle because of the urgency to get these regulations done. But that once comments are in, we can amend as necessary and live happily ever after and fix any areas that went too far. Well, I went through these hundreds and hundreds of pages of documents and comments, and I'm shocked that the situation is worse than I thought it was when I was lodging my objections. We are now on notice that if we pass these regulations, we'll be sued repeatedly and by many parties. The complaints are many and varied, including one that in cybersecurity, we've exceeded our statutory authority by being too prescriptive about exactly how the business must perform the audit, not simply defining its scope. 2, that the risk assessments compel speech and will be a target for a First Amendment challenge. 3, that the inclusion of the new term, behavioral advertising, invented in the regulations, which is not defined anywhere in the statute, is another example critics give of our overstepping our statutory authority. 4, this is something I pointed out in a previous meeting, critics are saying that the ADMT regulations will largely destroy, will destroy first-party advertising, i.e. from a business to its own customers. Not only was that not the intention of CPRA, we wrote CPRA in 2020 specifically to allow first-party advertising, since it was clear at the time from the Supreme Court case IMS versus Sorrell that would require all regulations to permit that. CPRA allows a consumer to tell a business not to sell or share that consumer's information to another business, which is very different than the ADMT approach here. 5, the assertion that the ADMT pre-use notification requirement is compelled speech. And 6, the extent that the extensive ADMT regulations present an unconstitutional delegation of power given the very brief and undefined mention of ADMT in the statute. These are just some of the legal challenges we know will unfold if we move forward with these regulations. We will be tied up in litigation for years. It will drain our young agency of resources. And what's frustrating to me is I've been sitting in this seat for I don't know how many meetings saying this exact thing would happen. And frankly, the chart we're looking at doesn't begin to explain just how much and how deep the constitutional challenges are raised by critics. This looks going to be an egregious waste of taxpayer money. We're going to be squandering scarce taxpayer funds that we have no moral right to waste on this effort. And what's particularly galling to me is that I agree with many of the critics that the ADMT regulations go far beyond what is justified in statute. I will say for the record that we took the language that's in CPRA around ADMT directly from GDPR. And the only thing, the difference we did is in GDPR, the ADMT is constrained by the word solely, as in solely automated processing. We left solely out because we didn't want that huge loophole in the law. But frankly, I wish we hadn't, because the ADMT language that's in these regulations seeks to regulate much more than privacy. It seeks to basically regulate all use of AI with respect to humans much more stringently than any law that passed out of the legislature last year. In addition, since we've last met, the Governor's Task Force on AI Regulation, which our fellow board member, Ms. Noneke, participated in, has issued guidelines for AI regulation, and the legislature is currently considering, I think it's safe to say, dozens of bills aimed at AI regulation. There's a robust effort in California to regulate AI now, and yet here we are trying to regulate AI through the back door of privacy. Let me repeat again, this is a privacy statute, not an AI regulation statute. If we enact these regulations, this will be a complete gift to those seeking federal preemption of our entire bill and agency. This action will play right into the hands of those seeking to get rid of our agency permanently and provide concrete evidence to the critics out there that we're off course and need to be reined in. And finally, I'm nowhere near over the cost of these regulations, which many, many critics point out vastly understate the total cost, since we're merely considering the impact on California businesses, not total costs. But even just in California, our own estimate is $3.5 billion of costs, 98,000 jobs lost, 31 billion of investment lost in the state. This is in the early years, when a lot of that cost is due to things like reinventing the cybersecurity wheel and adopting other standards, industry standards might be good enough. So for these reasons, I would like to propose a motion, which is as follows. Resolve that in light of the extensive comments received from the public, the new executive director and staff produce a report for the board on the cybersecurity, risk assessment, and ADMT regulations with respect to the potential for legal challenges raised in those comments, specifically around First Amendment issues like compelled speech, other constitutional challenges, and that the regulations exceed statutory authority. The report should address, at a minimum, the list of 6 possible legal challenges I just referenced earlier in my comments. I can reread, but I won't in the interest of time. The report should make recommendations to ensure that any regulations can withstand legal challenges. The report should also examine the potential cost savings available in the cybersecurity regulations if we accept other jurisdictional standards or technological standards like NIST, et cetera. Is there a way to achieve our cybersecurity functionality at a vastly lower cost? In the interim, agency efforts to promulgate and enforce regulations around cybersecurity, risk assessment, and ADMT should be paused. The director and staff should be given appropriate time to do the analysis to ensure that any proposed regulations can withstand legal challenges. The new executive director has only been in his job for 2 days, so he should be given an opportunity to get up to speed on these matters. Thank you.
Thank you, Mr. McTaggart. Our legal division have been considering these issues from the very beginning, and they have crafted these regulations in ways that match up with a statute that isn't always clear and isn't always very easy to work with, and in line with all of our legal obligations and with all of the sort of legal risks. And we know this, and we can't talk about legal risks in detail in a public meeting, of course. But these regulations have been through and have been developed in light of those concerns. Now, I understand your concerns, absolutely, but it is completely unclear to me why in the world you would suggest that staff haven't actually been keeping all of this in mind as they have crafted these regulations, when we all know that they absolutely have. And they have been, in my view, extremely careful and creative in creating a set of regulations that have a very limited universe compared to what the statute says. And our job is policy decisions. Our job is to say whether we think it's too broad. It's clear you think some things about it are too broad. That's absolutely the appropriate intervention for us to make. That's our job. And this is, what you're requesting here is something that is like not just off-piste. It's, it is asking for work that they've already done in some other form, and I just don't understand it. Yes, Mr. Liebert.
I actually just have a couple questions for my esteemed board member, Mr. McTaggart. I just want to make sure I understand. So the alternatives that have been presented on these various categories, I'm just curious whether you're feeling like it's the more dramatic changes in those, the various alternatives that substantially cut back a lot of these issues. To what extent, in your judgment, do they somewhat or largely address the overarching concerns that you've raised, or do they not?
Can I add to that with a specific question?
Sure.
Which is, if we were to remove behavioral advertising, which is first-party advertising, that's a big ticket item. That's something that we could absolutely discuss. Like, what would that do? And I apologize, Mr. Liebert. I just wanted to have like a concrete.
No problem.
Yep.
Thanks. Well, I think what I'd like to do is avoid sort of us going through this item by item right now, and in light of the fact that there is a robust body of evidence to suggest that some of the more well-funded and larger law firms in the country will be coming after us with these current regulations. And I think what we're doing here is not seeing a legal analysis, okay, like this is how we are going to address these issues. And what I'd like to see is a more comprehensive analysis, and to give the new executive director time to get up to speed on these issues of looking at kind of globally, these three areas which are so controversial right now, and saying, yeah, here's how we think we can address them. And it may involve scaling back. It may involve a different approach. It may involve, rather than us sort of sitting here saying, well, alternative three we think is better. And frankly, I think there's a lot of work to be done, more than just kind of, hey, here are the 4 or 5 issues that staff's identified. And again, I don't want to take anything away from staff, but
Sure.
But I don't know that this necessarily is the global approach I'm looking for.
Okay, and then my second part of the question.
Mr. Liebert and then Mr. Worth.
Oh, sorry. Just the second part was, just so I understand what that motion that you had made was, does it anticipate then putting some sort of a pause on the rulemaking process now in anticipation of that report that you are seeking?
Well, I don't want to get that prescriptive in the sense, I think it's what I said was, and I don't know if it's appropriate, but saying pause in the promulgation of these regulations right now. I mean, they're not being promulgated today anyway. I mean, we're in this process. If it turns out that it takes a week and they can come back with a report, maybe there's no issue and delay. I just don't want to put a constraint on, hey, you must get this done the next X number of weeks. We're talking billions and billions. The cost of these regulations, of these 3 regulations, vastly outweighs the cost of the entire bill by like an order of magnitude, and it's just, so I think we got to get this right. And this is the first time that we've had this many comments, this detailed, saying you are making a mistake and you will lose in court. The AADC lost in court, being very prescriptive. I take great pride in the fact that our original approach was crafted in such a way that we granted rights. We were very careful about not wanting to step over a line. We respected IMS versus Sorrell. That's the approach that CPRI took, and I feel like we're dramatically veering from that course now. And so I want to give the board and I want to give the new executive director and the staff time to evaluate these in a more global way, because I think we are this kind of adjustments here is the proverbial rearranging deck chairs, and I don't think that it's a global approach to revisit this that we need.
Okay, thanks.
Okay, thank you, Mr. McTaggart. We're all here, and what would you think? So we're all here, and we have a lot of substance to discuss, including from the comments. We don't have to decide to move these to a 15-day comment, which is the next thing on the rulemaking process today. We certainly can have a discussion. I'm uncomfortable with shutting down any discussion of what the rules actually say, but we can certainly have a discussion about what the draft rules actually say and not move it into the 15-day period. We'll have another chance to discuss things at a higher level, at a lower level in May. So does that respond to your concern?
I have no problem going through the discussion, but no, I have a motion that I'd like to make about getting a report back from the staff and executive director to deal with the fact that we have very explicit blueprints for how the critics are going to come after these regulations from what appear to me at first blush to be very credible methods of attacking us on First Amendment compelled speech, overstepping statutory authority. And
Are you asking for a privileged memo? Because we can't have a discussion with legal counsel in public session.
I am asking for a report that could be public.
Would it be privileged? You want a public report? Okay.
Yeah, and that it could include a recommendation about what the regulations would look like in a way that would withstand legal challenges.
Thank you. Mr. Worth.
So a couple questions. But I don't forget that we had this conversation, that just because we were moving it forward didn't mean we were going to keep moving it forward if we weren't happy. So I appreciate what you're saying, but as an example, the topic of AI. So this bill was written in November of 2020, right? The average consumer's knowledge of AI at that time, I know what mine was, which was nothing, okay? So how could we possibly infer that this bill intended for us to be regulating AI when AI wasn't a topic at that time? So if we start to take things like that out before we take the time to analyze the risks, would that be a better process that we could do? At the end, I was gonna go through my bigger picture, but you got there first, and I appreciate it. We do need to get this right. This just came out yesterday. The last 5 years, we created 81% less jobs in California than we did the prior 5 years. Was there a pandemic? Absolutely. Was that a big cause of it? For sure. But we need to do this. And unfortunately, I hate to say this, but if we need to take more time to get it right, it might take less time overall because of the risk that you're laying out. We're here. I'd love to take the time just to get input on the things that you've already prepared, to give you back and forth some comments, and then step back and say, okay, maybe we made enough changes. You have a smaller bucket to go analyze. Would that be a friendly amendment to your motion?
Sure. As I said earlier, I'm happy to go through these and give feedback on where we're coming. I don't think that this is the be-all and end-all, though. I think, and I'm very supportive if what you're saying is to take the AI ADMT out for now. I think you're right. You're spot on that the ADMT originally was really envisaged as a much narrower thing. If you're solely if it's 100% automated decision that had real legal effects on you, and it's now morphed into something that's basically regulating AI. So I'm concerned about that. Sure, we could put the motion on hold, but I'd like to bring it back.
Well, I wasn't suggesting that we put it on hold. I was suggesting that we may be analyzing a smaller deck after we have a discussion through that deck, or maybe a tighter deck by curing some definition problems. And I'm talking about removing an entire subject matter from the deck. So not to have staff, and if I assume maybe it's outside counsel, analyze AI, for example, because I'm proposing it doesn't exist.
So are you proposing removing ADMT then from the regulations?
Mm-hmm.
And, okay.
In conversation, I'd like to have a dialogue to get the answer. I just think that I don't believe, and I wasn't there, I don't believe we were intended to be regulating AI with this, in this organization, and I think plenty of other people are. And my view is it's a lot easier to dial things up a year or 2 or 3 from now than it is to dial them back down. And I think, personally, I think we've got to look at this as to the impacts. You threw out some numbers, but, Mr. Laird, there was a letter that you shared with us from the Department of Finance, September 30th. It talks about revenue decline of $2.7 billion initially, and then it says, but by 2036, it'll be positive $6.1 billion. Like, I want to get into what those numbers, you can't have a range that wide. I think the estimate of gross state product was negative $30 billion to positive $280 billion. Like, what does that mean? So I want to get into that stuff, say, how are we really impacting people financially? So there's more work to do, but I'd like to, try to make some progress on the regulations. I'm not talking about passing them. I'm talking about then analyzing the risks that we have. That would be my proposal.
That seems much more sensible to me. We don't even know what we have at this point.
Well, then I wanted to ask staff about somebody's view on the motion and get your feedback on it.
Thank you, members of the board. I guess, I agree with the sentiment that we're here today. We have materials prepared. Staff feels prepared to discuss these issues with board members. We have done the legal research, and I think over the course of this rulemaking process have, on multiple occasions, provided confidential legal advice to this board on these issues. So to say the work's not been done is a little bit frustrating to hear, and I don't think quite accurate from staff's perspective. So in terms of today, I agree. I think there's immense progress that could be made on these regulations if we start talking about the items we prepared. And then at that point, I agree with Mr. Wirth. If there is still concern about some issue that the board doesn't feel adequately advised on, staff can take that back and we can come back with that advice.
Thank you.
Yeah, I'm happy to go through these. I I think what I'm trying to say with respect to the approach in general is I feel like there have been confidential legal memos provided, but I feel like at a larger scale, the approach has been incremental and not kind of stepping back to say what is our general approach. And it's been frustrating to me because we have been basically keeping on, I think, trying to say what's the most expansive possible definition we can put in, and for a year and a half now. And now, finally, when we get these comments, we're giving some options here. I'm happy to go through the options. I do think, actually, Mr. Wirth, I'd actually support the notion of removing the subject matter entirely right now, because I think it's extraordinary the steps we're about to take. But I'm very concerned about all the concerns that were raised with cybersecurity, both the extent of the audit and the sort of legal aspect of have we overstepped our bound by prescribing. And I think I hear what staff is saying. Oh, we have looked at the legal repercussions, but when you look at just a wall of comments from industry that seem actually very credible, then it strikes me either we didn't consider it or we maybe didn't consider it correctly, because some of those comments were they were so repeated from so many different sources, not all in the same language, all bespoke, all sort of top firms, all pointing out precedent, all saying, this is where you're going to lose. And I was sort of after, hundreds and hundreds and hundreds of pages of this, which we've not seen before in any of the sort of, regulations. I'm like, yeah, we went too far on this. So,
Mr. Wirth.
So I don't think there's anything wrong with this. What we did is we went out, we specifically said we're going to open this up to get public comment. Some was from industry, some was from legal firms. Now our job is to digest that, respond internally, discuss it, maybe respond externally. That's exactly what we said we were going to do. So I'm totally fine with the place we're at. I do think if we think credible risk, we need to address it, whether it's internal or external. I don't care how we do it. I think this is totally fine. This is exactly what I wanted to have happen. And I appreciate where you were concerned then, and you're still concerned now, is that this car's moving. It's not in my mind. We've stopped it. We're analyzing where we were. I think we went too far in some places. I'd prefer to take a step now and decide we want to take a bigger step later. That's fine. But this is what we're supposed to do. This was our job, and, fortunately for me, you're doing most of it, but this is exactly where we're supposed to be right now. So let's do our job, and let's address this, and I would like to vote on that motion. I only tried to amend it to say, let's look at the risk after we adjust this today and see where we stand. But we'd be foolish not to look at that. So I totally agree.
Thank you, Mr. Wirth. I certainly don't disagree with that. I agree entirely. I just want to point out that staff would do that for us at the end of today, regardless of whether we have a motion to force them to do it. I think today is the day that we have an opportunity to have a pretty big conversation, and staff has teed up a lot of really important points for us. Certainly, Mr. McTaggart, the sort of thematic elements of your comments, have definitely been noted. And the only thing that I would ask of you in return is that to recognize that we do have some process constraints, they're legal constraints. And part of that, need to have the conversation at this point related to the legal constraints about when we have to do certain things. We are directed by the statute. It is mandatory for us to do regulations on on these topics. So, staff have been very, diligently working to do that. So I just, I want us to keep in mind that if we were to make the decision, for example, to take out ADMT entirely, that would be an entirely new form of risk that heretofore we haven't discussed exactly. Mr. Liebert.
I first want to just note that our staff has done exactly what we've asked them to do all of these months, and have done really extraordinary work. And as you noted, Board Member McTaggart, the language in the statute was very brief. From your experience, you specifically, along with others, did not use the term solely for good reason. And so it left open a lot of questions about, so what does this mean? And as you noted, Board Member Worthy, that that's our job now to try to find that balance. We want to maintain that innovation sector in this state that is remarkable, and we want them to be successful in those jobs that you noted as well. And we don't want to forget the consumers who are out there that you were worried about when you helped create this thing, and to make sure that as AI is expanding and changing, that we're doing the best we can, following our mandate to try to protect those privacy interests. So I think this process is actually a good one right now, that all the work that the staff has done on this will not be a waste, that it's helping to inform us in the most profound ways what those potential decision points are going to be. And so I think it will be useful for us to go through this analysis and then kind of catch our breath and see where we're at. So thank you.
Thank you, Mr. Liebert. What I'm going to suggest from a process perspective is, what I'm going to suggest is essentially that the board follow the path that Mr. Worth suggested, which is that we have the conversation and we see where we are at the end of that in terms of sort of what the assessment might look like.
Sure. Let's do that, and we'll talk about it afterwards. Yeah.
Page 3.
I'm going to be. Everybody's going to hate me. I'm sorry. I need a short break. Could we take maybe less than 10, if people can handle less than 10, and come back at 10:50? Thank you. Wonderful. Welcome back, everyone. We will get started on our discussion again. So, where we are is we're going to talk about some of the work that the public did and the staff did in thinking through some of the alternatives, and then we will consider more general things after we have a chance to discuss. I'm going to suggest that we actually move to the training thresholds and issue number 5, because that's something that has come up topic-wise in the discussion so far. But of course, I will defer to staff as to what you would prefer to do. But this is where sort of first-party advertising, which Mr. McTaggart has brought up a few times and brought up again, and I believe is the only place that artificial intelligence is mentioned in the draft regulations. So it seems like maybe a good place to start, a good substantive place to start. So this is, it's slide 14. No, we're just starting with
Jacob, can you please advance us to slide 14?
Does that work?
Yeah, we'll be happy to do that. So
Anderson? Okay.
I'm happy to, if we can tee it up a little bit. I think we have just a few remarks on that.
Okay, wonderful.
Absolutely. So this slide is really just to reorient everyone to what we're talking about when we talk about the training thresholds. And so when we talk about the training thresholds, they appear in 2 sections of the proposed regulations. In the risk assessment section, where if a business under the current draft processes a consumer's personal information to train artificial intelligence or automated decision-making technology that can be used for certain purposes in the regulation. So for instance, generating a deep fake about a consumer, it would need to conduct a risk assessment. The second place this language about training generally appears is in the AD&T framework. If a business is processing a consumer's personal information to train automated decision-making technology that can be used for certain purposes, it would be required under the current draft to provide consumers with the pre-use notice and the ability to opt out. On this topic, we did receive several comments from the public, including suggested modifications. So besides comments that were just generally supportive of the regulations, We also received several comments requesting that we delete the threshold entirely, that we replace the language capable of being used in the threshold with a different knowledge, likelihood, or intent-based standard. And the feedback that we received in the public fed into the proposed alternatives, which are presented for the board on the next slide. If we could turn to the next slide, please. Thank you. And so the three options currently before the board, though, as my colleague, Ms. Anderson, mentioned earlier, these are absolutely not exhaustive, is to leave the thresholds as they are, to narrow the threshold by adding a knowledge standard, and to remove the threshold from the risk assessment framework or the ADMT framework, or both. And of course, if, for instance, the board could always do some combination of these things, so keep it in one framework and not the other, and change it to a knowledge standard. So there are, again, a variety of options beyond just what is currently presented on the slide. And so I'll pause here for the board to discuss. And of course, staff is available for any questions that the board may have.
Thank you very much. We've heard a little bit today about, the legislature's activity on AI as a topic. I've done this also in many public talks, but I will again tout the governor's EO as well. And certainly there's quite a lot of work on the broad topic of AI in the state at the moment. And I think that I am safe in saying that nobody on the board wants to conflict with or cause issues with the broad work that is going on. It's a complex topic. We've heard about the wonderful innovation market for which California is known, and we know that there's a lot of interest because it's an important societal topic. So this is one of the reasons why I thought it might be helpful to start here. There is a challenge, and I think that it would be remiss of me not to state it. Like, we can't just say AI, because AI is defined in like a million different ways, and there are arguments about it. I was at a conference 2 weeks ago, and a computer science professor who works on AI models and was, addressing us about AI models said, in my classroom, a regression on a spreadsheet is AI. So, I think we want to be careful about the terms here because we are bound by the statute to do some things. But that said, to the extent that we're wandering into territory that we don't need to wander into, I think it would be great for the board to have a discussion about these alternatives for a couple of reasons. One is that for the risk assessments only, that's why it's in green language. Specifically, the draft regulations mention artificial intelligence. And then secondly, and related to that, but really related to another big ticket item, as I saw it in the comments, is something Mr. McTaggart mentioned earlier, which is to do with first-party advertising. So while I disagree with the comments, that say that we don't have the authority to do this, that's not really the question before us. The question before us is to what extent should we exercise our authority as a policy matter to protect the fundamental privacy rights of Californians and pay attention to the effects on innovation and business. Like, that's the job before us. Staff have worked out very carefully the authority question. That's not, whether I agree or disagree with some of the comments on that, that's by the by. But AI kind of as a topic and the first party advertising, those were things that were very sort of passionately and repeatedly discussed in the comments. And so this is the reason why I think I really value and appreciate the alternatives that we've been given here. And I think it would be a good thing for us to discuss at this moment.
Yeah, I think in general, this is going to get back to what I was saying. This, again, feels like we are focusing on a technology. So the training of the ADM and how it's going to be used. And again, I think the language in the statute is where the processing presents significant risks in 185A15 for the risk assessments, and of the cybersecurity. It's whether the processing presents significant risk to consumers' privacy or security. And I have this hard time always because it's like saying, you know, if you use this technology, we say that's risky. But again, I can make the argument that that ADM is more privacy protective because I don't have, you know, Jeff looking at my information when he makes a decision. So I'm concerned about that. And I think with respect to that's my general point. And again, this is where I'd like to have a more holistic view of all the regs from this perspective. But in general, I think I'm on the less is more here.
Thank you. Mr. Wirth.
So a couple of things I'd love to get your feedback on. I think, you know, we went from capable of to should know would be used or will be used. I kind of feel like, you know, you can't give me a speeding ticket for driving a fast car unless I'm speeding. So I'm totally comfortable with saying if you are doing it, not could you, do you have the capability of doing it, or you should know that it might be done later. When you're doing it is when it's an issue. I think there was, you know, unfortunately, I was actually trying to find it. It's not easy, but there was a letter from a Rebecca Prozon that gave an example on the first party issue. If you run an ad on a restaurant in Los Angeles to residents in Los Angeles, that you need to do a risk assessment for that action. I'd love to get feedback if that's accurate, and if we agree with it, meaning do we really want to put people in that position if it is accurate? I've tried to find the letter and I can't, but you might be able to you might remember that.
Could I ask a clarifying question real quick? So the information that is being used, the target is all of Los Angeles, and the information being used is like you're in Los Angeles.
Yeah, I mean, basically the entire sentence, I think, said, the example that was given was, I wrote it here, showing an ad for a restaurant in Los Angeles to residents of Los Angeles. That was would require a risk assessment. That was the quote in the letter.
Thank you.
I didn't get the date of the letter, unfortunately. And then the third, maybe it's third, I don't know what number I'm on, but the final input I'd love from staff is, because when I see the alternative two, and this has happened in a couple examples here, we completely remove it, I go, whoa, right? Tell me more about that. Like, what does that do? Because I don't have the ability to see the whole document and how that impacts us. I understand making some small changes, but when you take the whole thing out, do I feel better or worse about that? I'd love to get your feedback on that.
I'm going to let my colleagues take the first question, and then I'm happy to help answer the second question in terms of taking it all out.
Okay. So first, with respect to with respect to your first question, is it about the alternative one that's currently here, the use of a knowledge standard? I just want to make sure we're being how to respond.
I think you made progress from the original to alternative one. I think there should be an alternative 1.1, which just says if you are actually using.
Absolutely. So that is helpful feedback for us, and we did receive comments that talk about, you know, if you designed it for these uses, if you're using it for this, if you intend to use it. And so there's a spectrum of different standards that could be used for this threshold. And that would get to, I think, one of the concerns that appears in both the comments, but it also appears prevalent in the discussion today, which is about just like the breadth of what would be covered. And so that, again, in terms of changing this standard and making it a bit more precise, that is absolutely something staff can do. And it would basically just continue to narrow what, and provide clarity about what is and is not in scope when you're processing consumers' personal information to train, for instance, a facial recognition technology. And so, of course, I'm happy to go deeper into this issue. Turning to your second question about, you know, is an advertisement to Los Angeles residents let's just, for the purposes of this example, by a business, is it subject to the risk assessment requirements? So under the current draft, there's a couple ways it could happen. So first, if the way the advertisement is displayed is through selling or sharing the consumer's personal information. So for instance, if it's done through cross-context behavioral advertising, then it would fall under the first proposed threshold. The second way it could happen, I don't think this is necessarily what your hypothetical goes to, but say, for instance, they're using sensitive personal information, so precise geolocation information, not just that they're in Los Angeles, but that they're specifically being tracked with their precise geolocation. So the second way it could be is through the processing of sensitive personal information. On these first two thresholds, I will say that these first two thresholds are very common in state privacy laws in the United States that require risk assessments, or they're often referred to as data privacy impact assessments. So for instance, under those first two thresholds, you would see them under Colorado's law, under various other state laws. I believe there's over a dozen, actually, like much higher than that at this point. And then the third way, and this I believe is a topic that I think the board is very interested in discussing, and we've tapped in as issue 3, is if the business is engaging in profiling for behavioral advertising. So that threshold had been originally recommended by our new rules subcommittee and had been approved by the board for inclusion in the framework in December 2023. So it's been quite a bit of time since that original discussion happened, and that had been due to concerns at the time about consumers' ability to control their information in the context of behavioral advertising. So that could be the third way that a business would be required to conduct a risk assessment. And again, that threshold is something that we've teed up for discussion because of the breadth of comments that we've gotten on that. And so those are essentially 3 potential ways that a business could conduct a risk assessment depending on the nature of how they're conducting the advertising.
I apologize. Can I piggyback on that comment for or that question for just a moment? If if profiling for behavioral targeting were removed, would we be covering profiling? I'm again thinking of the statute, which says including profiling.
Absolutely. So I'm going to address this in 2.
Sorry, one more thing, which is that because as I understand the way this operates, the statute says including profiling. We have a very small set of of what profiling is. We have a very small subset of profiling that's right, that would be covered by these regulations. Only extensive profiling, only these very, very certain things. And I just want to understand if we would suddenly not be covering profiling, and then we have to think about that.
Could you repeat the first part of your question, because I didn't get it all?
So the statute says opt-out rights for automated decision-making technology, including profiling. Profiling has a definition that is significantly broader than anything that's covered by these regulations. Staff have dealt with this in a couple ways. One is through the concept of extensive profiling only, right? And then there's this, and so I'm just trying to get my head around, because as Mr. Worth, I can't move around mentally in the regulations like you can. What the sort of ramifications would be.
Absolutely. And I think your question, Chair Urban, will also help me speak to Board Member Worth's third question, which is just, how do the potential options before the board affect the larger framework and the bigger picture? And so I think one thing that could just be helpful is, again, where do these thresholds show up? So profiling for behavioral advertising and training, the training threshold that's currently on the slide. So they show up in the risk assessment framework, and they show up in the ADMT framework. And in this case, inclusion of both of these frameworks is within the agency's authority for risk assessments and ADMT, because as Chair Urban with the ADMT framework mentioned, ADMT under the statute explicitly includes profiling. Now, it is ultimately a policy question for the board of whether or not you want to exercise that authority to address these 2 types of processing now. And so this, in terms of what your question, Chair Urban, of what happens to the profiling threshold, it would just mean that in terms of exercising the agency's authority here, it's just choosing not to in this specific context. And then Board Member Worth, in terms of your question about how does this affect the bigger picture, of course, it depends on ultimately what version of this the board is interested in pursuing. But let's say hypothetically, the board wants to remove profiling for behavioral advertising from the framework. That means that a business would not be required to conduct a risk assessment if it's engaging in profiling for behavioral advertising. Though I will, again, disclaimer here, if a business is engaging in cross-context behavioral advertising, that would be covered under the first threshold, which I don't believe we didn't really receive nearly as many comments on that, and it is consistent with how other privacy laws require similar risk assessments. And then similarly with the ADMT framework, if you remove profiling for behavioral advertising, then for first-party advertising, not cross-context, businesses would not need to provide a pre-use notice, opt-out, or access rights. So we're simply just lifting it out of the framework and narrowing the scope of the universe of what ADMT profiling the board wants to regulate right now. Similarly for training, that's exactly what would happen as well, where if the board, for instance, decides to narrow I'm just going to, again, hypothetically, for alternative one, if you narrow it to a knowledge, intent, design-based standard, you're just narrowing the universe of how many businesses are conducting risk assessments. And similarly, for training ADMT, if you would narrow how many businesses would be subject to the pre-use notice and opt-out requirements. And as with profiling for behavioral advertising, if the board simply wishes to just list these out of the framework entirely, you would essentially have businesses, they would not conduct a risk assessment for training, and they would not be required to provide notice or opt-out abilities for training. And so that's the bigger picture of how these thresholds interact with the framework overall.
Mr. McTaggart.
Thanks. Ms. Worth, I thought I would just add a little more clarity. So for me, the problem with having this in here with respect to both risk assessments and ADMT is it does end up, I think, if you walk through how this impacts because of the inclusion of significant decision, and then you walk through the definition of significant decision, which includes the access to, denial of, you end up in a world where basically I think contextual ads don't work. And that's what I think people are objecting to so much. You know, first party doesn't work, contextual doesn't work, because people can just say, because you're going to need clearly some kind of automated system to show people ads. You know, that's just the way it works in life.
Carved out, though. It's carved out of the definition of ADMT, which is the absolute threshold for the whole thing. Not for the
provision of or denial of, because the definition of significant decision is so.
But you don't have a significant decision until you have ADMT. You have to have ADMT first, or please tell me if I'm wrong. So there's no regulation of something that's not ADMT.
That's ads.
ADMT doesn't include contextual advertising. It specifically says that. It has said that.
It's going to include first party.
So there's the question behavioral advertising for first party, which is the slide that we were just looking at. But it is not, it does not.
Not even behavioral, just advertising to first party.
It does not cover contextual ads as I understand it. Please correct me if I'm wrong.
No, that's correct. It does not cover contextual advertising.
It has not covered contextual advertising as far as I know from the get-go, and certainly since the revision after December 2023, it simply does not cover that.
Well, I think it covers first-party advertising for
behavioral targeting, not contextual.
Kind of any way you want to cut it with first-party, which clearly the statute doesn't support.
It doesn't cover contextual advertising.
First-party advertising, it does.
It does not. It does not. I have to find the page, but it's in the definition of ADMT, which, remember, the regulation then applies only to something that falls within the bucket of what is ADMT. You do not get to the rest of the requirements unless you have an ADMT. You do not get to a significant decision unless you have an ADMT. If you don't have an ADMT, it doesn't matter what kind of decision you're making with it. In the ADMT definition, I think it has an A and a B, and B explicitly carves out contextual advertising.
If you look at the definition of behavioral advertising in the draft regulations, it's 7001 G sub 2, where it says behavioral advertising. Oh, no, that's okay. There are too many definitions. Not too many, just there are a lot to look at. But G2 specifically says behavioral advertising does not include non-personalized advertising as defined by CIV code 140 subdivision T, provided that the information isn't used to build a profile about a consumer or otherwise alter their experience outside the current interaction with the business and is not disclosed to a third party. So that is the carve out to make clear that it does not cover contextual advertising.
Apologies, I set the carve out in the wrong place, but it's still at the top of the concern.
Just one thing I'll add here, though, is I think, Board Member McTaggart, what I'm hearing from your comment is just, like, you want to ensure that it's clear to businesses that contextual advertising is not covered. And the regulations can always do that even more explicitly, to the extent that the board is concerned that there's ambiguity still, is just making even clearer or removing language that you think is introducing this controversy or clarifying it further. That's also an option before the board, is if there's specific language that you're like, this needs to be removed, or it needs to be made way more precise, or we just need to have a very explicit carve-out that it does not apply to this and provide examples of what it does not apply to. Those are things that the regulations can also do in a targeted and surgical manner.
But to be clear, the statute absolutely permits behavioral advertising based on first-party data for a first-party customer.
That's the second question.
It's clear. It permits it. It's designed that way.
I mean, contextual advertising is the first question, and it says behavioral advertising does not include non-personalized advertising as defined in 1798.140. And then they have to have, like, a caveat because of the profiling language in the statute. And then the second question, absolutely, just to be clear, I'm just trying to tee up the policy question we're discussing here, is the question for behavioral advertising, which is targeted. So targeted advertising based on personal information. So, that's a question that's before us separately.
And just to be clear, whether or not the statute allows for contextual advertising, that's not the question in front of the board right now. The question is whether or not you need to conduct a risk assessment about that processing of information. So just because the statute allows it, the question before the board now is, well, it allows it, but should I do a risk assessment? Should I require a business to do a risk assessment regarding that processing?
My answer is this: when you look at the language in 185A15, the governing language presents a significant risk to consumers' privacy, and I don't feel it presents a significant risk to consumers' privacy. I'm dealing with my business that I know I'm dealing with. They have my information. They show me an ad.
So contextual advertising, I 100% agree with you. And so you're talking about targeting, first-party targeted.
I know I'm dealing with whatever the firm is, and so I've given them my information. They show me an ad. Generally, I can opt out of that if I don't want to get it. Nothing was ever intended to stop that. In fact, we overtly meant to allow businesses to continue to advertise to their customers.
So I think we have at least a couple of options here. So we have the really thoughtful options you've given us, and a couple. We have one additional option that occurs to me on the three alternatives that we have here on slide 15. One is to remove the green language from the risk assessments so that we are not referring to artificial intelligence. And another that I'm hearing, I think, we haven't heard from Mr. Liebert yet, and Mr. McTaggart and Mr. Worth, please tell me if I get this wrong, is some support for alternative 2. Is there, maybe? Okay, Mr. Worth, you want to comment on that?
2.1.
2.1.
Yeah, which is, we discussed it already. It's just tightening that up to actual
non-standard.
Okay, great. And what do you?
Sorry, just to finish that. Should know that it will be used. What I wrote is simply is using. I am trying to shrink the universe.
I see what you're saying.
Those that are actually doing it versus could, might, will.
Would knows be helpful here? So just deleting the or should know, would that get to it? Or would you prefer just saying is using?
I would, but I'm only one of 4. And really, Chair, it came from when I looked at the original language, right? So I just moved it all the way to the other side of the chart.
I just wondered why I had Mr. Worth to ask him what he thought about the artificial intelligence.
I think I was hopefully pretty clear about that. I think it comes up, that term, I believe, is used 17 times. And I think we need to make sure we get rid of all 18 of them. So that makes it clear.
Okay, thank you. That makes it very clear.
I'd like to, again, I want to push back on this. This has got nothing to do with behavioral advertising. If you go through risk assessments, significant decision is a decision that results in access to a provision of denial of this whole list of things. If you go to number 4, it's processing the PI of consumers to train ADM that's capable of being used for significant decisions. It's got nothing to do with behavioral advertising. If you show ads, you're going to have to do a risk assessment. But it's got nothing to do with, leave aside the whole definition of behavioral advertising doesn't even come into it. The way this is written, if you show an ad to your own customer, you have to do a risk assessment. And that to me is crazy. It's Article 10, 7153A, that defines significant decision, and then 4, or just 3. I mean, so this is the kind of thing where I think we need to take a step back, because it can't possibly be the right outcome that, you're showing ads and that means you're doing something risky. And so I think that there were a lot of comments about the whole access to, this was my comment at an earlier meeting. If I don't see an ad about a hospital, or I don't see an ad about a grocery store coupon, have I been denied a opportunity? And that got back to my comment some meetings ago, like, you're going to take 75% of the economy and you're just basically going to say you can't show ads anymore, because if I show an ad to Mr. Liebert but I don't show it to Mr. Wirth, have I denied Mr. Wirth the opportunity because I didn't show him the ad for the hospital? I think it's nuts.
I think you're simply misapprehending the way this works mechanistically, but again, I could absolutely be wrong. I could have read it differently, and so I'll ask if the legal division can clarify.
Sure. I think there are several issues at play here, and a lot of them go back to the definitions. So the reason that we teed up the definitions first is that they're at the heart of a lot of the regulations. A lot of the thresholds refer back to them. And to Board Member McTaggart's point, when we're talking about the definition of significant decision, removing the term access to, which seems to be kind of core to many of your concerns, is one of the issues that's teed up for the board's discussion today. So, and similarly, the deletion of the term essential goods or services, with the few examples that we provided for clarity's sake, that also has been teed up for the board's consideration, and significantly narrowing the definitions then flows down to significantly narrow the thresholds and therefore the requirements upon businesses and the rights for consumers. So it's kind of hard to talk about a particular concern in isolation when it does relate to definitional issues.
I get it, but the problem with showing an ad, and the way we have not defined provision or denial of. And so the question is, if I don't see the ad for the grocery store coupon, have I been denied the opportunity that Mr. Liebert did? And I think we're just vagueness, and I think we're opening the door to really massive ramifications with respect to advertising. And again, I'm the person who decided to try to start this whole thing off to try to constrain the untrammeled kind of trafficking in our personal information. And at the same time, I'm very aware that advertising supports the internet. So, we gotta have some kind of reasonable balance here. And this, to me, is taking a blowtorch to something that is really going to have a massive impact. And I think this did and does continue to call into question the basic provision of ads in a huge amount of the economy.
Thank you, Mr. McTaggart. Mr. Liebert, and then Mr. Wirth.
For me personally, it would actually have been helpful if we started from the beginning of this presentation, because some of these things that we're talking about will, I think, as you pointed out, Madam Chair, might be addressed by the fact that we've all said, yes, let's take out behavioral advertising.
Yes, I think I was trying to be I was being over efficient.
Yes. So I'd like to urge us to go allow the staff to start with these definitions as planned, and I think that will address some of these questions.
Yeah, apologies to everybody. I thought it was worth a try, because it does knock a lot of stuff out if we make a decision. But yeah, it's clearly challenging. Thank you, Mr. Liebert, for that intervention. Mr. Wirth.
Yeah, I just want to be clear. If there's any ambiguity that this language would do what you're saying regarding, if I'm providing my information to somebody and they want to send me an ad, we have to be super clear that that's not regulated here. So just whether it is or it isn't, let's just, at some point, it doesn't have to be now, follow back up with that so we're all clear that, and maybe add some words that you don't think we need so that we feel better about it, but let's just close the loop on that, because that we cannot have open, that door.
And I'm sorry to bring this up again. But to be clear, Mr. Wirth, are you referring to contextual adds, which are things that relate to sort of whatever you're doing in that moment, what you're reading, et cetera? Are you also referring to, Mr. McTaggart described, the first-party business that you're referring to the second as well? Yeah, I just want to be sure staff understands.
Exactly, first party, yeah.
All right, team, shall we take it from the top? My experiment.
Sure.
I think this has been an illuminating conversation, actually, and maybe it will be more helpful for the board, because again, we're doing our best up here, and we are not you really have the understanding of how these things fit together. So let's take it from the top.
Well, and I'll just jump in to say, I think we have kind of presented at least the definition of ADMT issue already. We can restate what we said earlier. Again, sort of a non-exhaustive list of alternatives, alternative one being a more expansive scope of that term, as advocated by some commenters. Alternative two being sort of a more precise articulation maybe of what was originally there, essentially saying ADMT is only that technology being used or decision-making technology that doesn't have a human involved that fits those certain criteria in 1, 2, 3. If a human's involved in that regard, it means that ADMT is not in scope of these regulations at all. So that's another option for the board to consider. And then alternative 3, of course, being the solely using kind of the confinement of solely automated decision-making. But I think even as board member, Mr. McTaggart noted earlier, that was intentionally left out of the language in our underlying law.
Thank you. I have a question. I mean, I realize that, and I really appreciate that the legal division is, mainly you're giving us legal advice, and you're analyzing the legally based advice. You're analyzing the comments and sort of teeing things up from that. So please tell me if this is not something that that you think this is just in the board's bill, but I feel like I don't have quite enough information, which is with regards to alternative one. I did notice in the comments, from some parties, a desire for us to align with the government code, that it's already in there. And you've mentioned that would be a broader definition of ADMT than we have now, which would, practically speaking, mean the regulations capture more activities, perhaps by more businesses, sort of depending on what they're doing. What, if you can say something about this, what effect would it have just generally on how sort of our law, our regulations interact with existing state law, existing regulations? We've been trying really hard to, where we can, to harmonize, of course, generally, and it seems important to do that in the state of California. But if that's not, a big concern, then I think we can just discuss only the question of the broadening.
Thank you. May we please switch to slide 6, just to bring those definitions back up? Okay, thank you. So I think with respect to alternative 1, to the chair's question, there's a benefit to harmonizing with existing language that's being used in the state. The government code and the state administrative manual apply to how the California government uses these automated decision systems. That's kind of what alternative 1 is based upon. We would have to deviate in certain respects from that definition, because for alignment with CCPA, we need to use certain different terms. And in addition, as I flagged earlier, we would have to define, for clarity purposes, to meet our APA clarity requirements, we would have to define what it means to materially impact consumers. But to your point, using the alternative 1 definition would broaden beyond what's in the currently proposed regulations, so that it would cover automated decision-making technology that assists human decision-making, as opposed to just replaces or substantially facilitates or substantially replaces human decision-making. So alternative 2, on the other hand, does reflect kind of that the close alignment with Colorado and GDPR. It recognizes and draws directly from GDPR, specifically EDPB guidance about when automated decision-making technology is, quote, solely automated as opposed to human involved, and with the Colorado regulations that talk about what or that discuss meaningful human involvement. And so each of the provisions that are included in alternative 2 are drawn directly from those other privacy jurisdictions and those concepts, but also made clear for APA purposes. So Alternative 2 most closely aligns with the recommendations that we received to draw more closely from GDPR in Colorado.
Thank you. And if we were to go with, let's say, for argument's sake, Alternative 2, do we get crosswise somehow? With the state or with something else?
No, there's not really an interaction between like the California State Administrative Manual or Government Code, because that's talking about how the state government uses these types of technologies, and we, on the other hand, because of CCPA's exceptions and its scope of jurisdiction, does not apply to state uses. What we would be doing would be regulating businesses' uses of these technologies when they're using them in the ways that are set forth in the thresholds.
Wonderful, thank you. Yes, Mr. Liebert.
And just to follow up to what you asked in terms of existing state law, we are appropriately watching carefully what is happening in the California legislature, as well we should. And how does this definition in Alternative 2 comport with, essentially with what the legislature is focusing on in this regard as well?
I think I would say, again, sort of to date, what we've seen in ledge proposals, even this session, do align more with that Alternative 1, automated decision systems. But at the same time, it, in my opinion, does not create a conflict for us to proceed with a more restrictive Alternative 2. And in fact, what it does is then provide some deference to the legislature to sort of fill those gaps and sort of expand, consider more expansive technologies. We would be taking a more narrowed approach and focusing just on, again, issues that focus on privacy issues and align with our other states.
Wonderful, thank you. Mr. Worth.
Just a question. Well, in general, I think that is what I'd love to hear, that we're going to be a little tighter, let someone else, and if we want to adjust it later, we always can. But when you mentioned, this is such an important definition, right? When you mentioned that it draws on GDPR in Colorado, just a really dumb question. Why don't we just use those definitions? What do we find the fault?
Great question. It's such a good question, because I looked at Colorado, and I was like, oh, I think they will.
I mean, if it's a long answer, you can get to me later, but, okay.
No. The issue really comes down to APA clarity requirements, which we are subject to these for our regulations. They need to meet certain requirements within that law. And so for us to use things like meaningful information about the logic involved doesn't quite meet that. We need to provide more guidance on that. So that's exactly what Alternative 2 does, is take the concepts from Colorado and GDPR and flesh them out in a way that meets our APA clarity requirements.
That's helpful.
This is probably unhelpful, but I will say that, the APA requirements in California are really valuable, again, because they have like these strict requirements of clarity. But it is so frustrating that we can't do things like say, give a standard to a business and say, please do this reasonably. You know your business, like you know your customers, you know what's going on, and we simply can't do it. And so, Colorado has this very sensible kind of, approach. So thank you for the explanation. And Mr. Worth, I think I interrupted you.
No, that's okay. I'm now stepping back a bit. Is the goal for us, and I want to see if us four are on the same page, is your goal for us to take this and say, we like Alternative 2, or we'd like you to adjust it for these reasons, and then go to the next page?
That is my goal, yes.
Okay, I figured that. I probably was stating the obvious, but does anybody have any discussions about Alternative 2?
I'm good with it. Let me just ask Mr. Liebert if he...
Well, I'm going to reserve because I want to hear Member McTaggart and then...
Okay, sorry.
Yeah.
So, I hear this, that, okay, we can't use Colorado because it's too vague. And so I guess kind of what I would like to see is a red line of Colorado where we amend it and just say, okay, we need to add this to make it less vague. Because, again, this is us just kind of reinventing a wheel here. And when I look at this, I see vagueness. Does this mean... I think number one is, okay, I'm a clerk in a hotel. The person calls me up and says, I'd like to book a room. Well, I know how to interpret that, so that can't be used it. I kind of wonder what 1 through 3 adds. In Colorado it says human-involved automated processing is automated processing of personal data where a human engages in a meaningful consideration of available data used in the processing or any output of the processing, and 2, has the authority to change or influence the outcome of the processing. And so I kind of actually prefer the meaningful consideration. Now, maybe you're saying that that's too vague here. But again, so I'd want to consider this. I mean, I'm looking at it, I kind of know where you're headed. 1 and 2 don't actually seem super clear to me. And so
Sorry, by 1 you mean alternative 1, the state?
No, little sub 1 and 2.
Sub 1
and sub 2 in alternative 2. I don't see, I don't know that number 1 is any clearer than the Colorado language of a meaningful consideration of available, available to use in the processing. But I think we're trying to get to the same place where you have this distinction between people being involved and people not being involved. Mm-hmm. And then you have to turn it on its head and just say, if people are, the other thing that I think the architecture is completely backwards from Colorado to us is I think you should say, if humans are involved, there's no opt-out required. We have this backwards thing where you say, you can opt out and you can come back in, but business doesn't have to offer the opt-out if people are involved, I think is what I would start with.
Well, okay. Go ahead.
Go ahead, Phil, if there's something you'd like to add.
Well, I would, again, I think you hit the nail on the head that meaningful information is not clear enough. And so I think what we're seeking to do is articulate that. Sub 1 describes that essentially that human, the meaningful information they need to know is they need to know how to use the technology, how to interpret it, and how it makes a decision. Essentially, I guess what I'm trying to say is we are, when you say if a human is involved, it's not subject to this, but I guess I would push back and say, what is your standard for human involvement? And that's what we're trying to articulate by this definition.
Yeah, and can I just give an example that is outside of our regulation because of 1798.145, so that I'm not commenting on any particular business practice that we regulate. I recently read an article about a major health insurance company's process for considering medical claims. And they had the relevant insurance law, I think in some other state, requires a doctor to review a denial of a claim and make a decision. And one doctor they uncovered made 60,000 such decisions in a month, because what was really happening was an automated process was teeing up dozens of these things at a time, and the doctor was just checking the box. And so I'm sorry, that is not meaningful human involvement, and this is my concern with just saying solely, because it isn't just a loophole, it just obviates the entire point. So, we can certainly talk about what we're comfortable with. And I think there are real questions. For example, at what point do we need a human? At what point do we need a human? I would say probably before it's actioned, before a decision is actioned, that affects the consumer. But there are some sort of fundamental challenges that we might need to think about, or maybe we need to be again a little more narrow, maybe alternative 2, and receive more comments, of course, and see if we've gotten it right.
One thing I'm happy to get comments on our alternative 2, and I think we all are trying to figure out where the right line is. The interesting thing is when you look at the GDPR construct, and that's why we left out the solely, because you didn't want someone just hitting that thing. GDPR has a very different kind of turns it on its head a little bit, and it says the data subject shall have the right not to be subject to a decision based solely on automated processing. In alternative 3, our definition of automated processing includes the purpose of making a solely automated decision. That's a slight distinction. ADM you could define separately, and then if it's used in a certain way, and that's what I find in our whole approach. We've defined ADM as the enemy, whereas GDPR I think more correctly defines how it's used, because this alternative 3 defines ADM when it's used for solely automated decision. So anyway, that's just a slight difference there.
Thank you. Is our guidance here that we would like staff to work with alternative 2? And if I'm conveying this properly, Mr. McTaggart, let me know, otherwise correct me, that part of what we would like to see is, so alternative 2, and like a red line of the equivalent Colorado language that could be more doable in California.
If it's helpful, I can kind of walk you through where these provisions came from with respect. It's effectively an oral red line between Colorado, GDPR, and Alternative 2.
I think, you know, to the extent that we're going to put this out there and get more comments back, I'm happy with it. But what I wanted to do, the reason I wanted to talk about the ADM, though, and I'm not sure this is the right area, but the 7221 B2, again, what I'm talking about, the architecture of the substantially replace human decision-making. We say, you know, you don't have to offer the opt-out if you have a reviewer who can review. And I think that's completely backwards. We should be saying, if a human's involved, you don't have to offer the opt-out at all, period.
That's if the board chooses to go with Alternative 2, then things that have the human involvement that's described in Alternative 2 would be out of scope for everything for the ADMT requirements in that section. So that's why we wanted to start with the definitions, because, as mentioned before, when you significantly narrow the definitions, that significantly narrows everything else that flows from those definitions.
Okay, so I haven't actually worked through all the thing, but if we did this, then as a company, you would not have to offer an opt-out at all as long as the person was this. Okay, that's better.
Yeah, it obviates the opt-out part, or that the human involved, or the human decision maker opt-out.
Having this qualified human involved that meets these criteria gets you out of this entire regulatory scheme.
Correct. So would it be helpful to do that kind of quick oral walkthrough of GDPR in Colorado with respect to Alternative 2? I don't want to belabor the point, but I'm happy to go through that.
I don't think we need it now.
Yeah, I don't think we need it. I do think it's,
okay.
Yeah, if you're going to follow up with it in writing anyway, we'll.
Yeah, presumably with some info about the next round and, yeah, okay. Okay, Mr. Liebert, you didn't have a chance to weigh in. Are we we have a consensus about this? Okay, as long as we've got a consensus, wonderful. So that gets us to issue 2, I believe, which is slide 7?
Yes, slide 7, please. Okay, so the second issue is the definition of significant decision. This term is defined within the risk assessment and ADMT articles. This slide displays a simplified version of the definition in the currently proposed regulations. Public comments make various recommendations with respect to this definition. Some recommend leaving it as is. Others recommend using GDPR's language of, quote, legal or similarly significant effects. Some recommend deleting the terms access to and deleting or clarifying the terms essential goods or services. While the agency can conceptually harmonize its significant decision definition as much as possible with GDPR and other state laws, it can do so only to the extent that doing so would be consistent with CCPA and the APA. The proposed definition does already leverage concepts from GDPR and other states' privacy laws in this way. If we can move to the next slide, please. The board has discretion about how to define significant decision, which includes how to modify it at this stage. We do need the board's guidance on each of the 5 alternatives that's included on the slide. The alternatives reflect feedback from public comments. So the first is deleting access to as unnecessary, or replacing it with selection of consumers for. The second is deleting insurance. The third is deleting criminal justice. And the fourth is deleting allocation or assignment of work. And finally, number 5 is deleting essential goods or services or narrowing it as appropriate. So now that we've provided the overview of the alternatives for the board, we'll pause for the board to discuss.
Thank you so much. And I hate to do this, so just feel free to tell me that you decided that this wasn't worth our time today. But one of the things I noticed in the comments was somewhat of a confusion over what's exempted entirely from the statute and thus from these regulations. Again, you know, reading just bits and pieces without understanding the entire whole, how it operates, and how it lives within the statute, which is it. Like, that is the extent of what is covered and what falls within our jurisdiction. I saw some real confusion about certain kinds of personal information, certain kinds of data that I think didn't seem to, be aware or weren't putting together correctly everything else with 1798.145 and 146, which just exempted stuff, like a bunch of stuff, like straight out of the statute. And I noticed that you've put that into the definition. I was expecting to provide clarity. I expect that was to provide clarity and help people with this, really difficult mental task to put it all together. I know it doesn't make a difference legally at all. Like, that stuff is just exempted. And so this isn't about like what would happen in terms of the effect of the regulations, because it legally doesn't matter. But I wonder if it would be helpful to folks if this like carve out was restated kind of in a more general way at the beginning of the regulations, or I don't know, if we put it at the beginning of one section, I think we run into the same challenge that I'm going to mention, which is that sometimes I think it can be, I've written a number of contracts and I've written some, it can be actually become a little more confusing if you repeat it in some places but not others. So I'm just wondering your thoughts about that. We can also just table it if you want to think about it. It's a minor thing because, again, it doesn't change the effect of the regulations at all, but I thought I would mention it.
Certainly, I think staff could propose sort of an alternative placement for that. And to your point, you're absolutely correct. I think the goals originally were just to remind sort of anybody looking at these regulations that there are important exemptions in the CCPA when you look at this list of significant decisions. I'm just going to give a few examples. For instance, financial services. Obviously, we can think of a lot of things, credit card applications, bank accounts, things of that nature. But that's almost entirely information subject to the Gramm-Leach-Bliley Act, which our law says is exempt from our jurisdiction. So I make that example simply because we felt it was important for people when looking at these big categories of information to understand it's a nuanced analysis that has to occur to understand whether or not it's actually a decision that's covered by this provision. So.
Thank you. And that's not a function of the provision. That's a function of the statute.
Of the law.
So, yeah. Okay, so comments on this one. Mr. Wirth? Mr. McTaggart?
Yeah, Mr. Wirth, that's helpful. I was going to, whether on this page or the prior one, the two of the things that are remaining on your proposed, I'll call it alternative one. When you say the word housing, what exactly are we trying to get at? I stayed in a hotel last night. Is that housing?
So that's a great question, and I would note that.
Sorry, just to add on.
Yeah.
And if there's some other regulation or law out there that further defines it, like you just explained for financial or lending services, let me know.
Well, so I'd say the biggest exemption to keep in mind is the Fair Credit Reporting Act. Information subject to that and lawfully complying with the Fair Credit Reporting Act is exempt from our law. Again, when it's in compliance with FCRA. So, for instance, a housing decision being made based on a consumer report subject to that law would actually not be covered by this. I'm going to look to my colleagues to make sure they're not going to shake their heads, no, you got that wrong. Okay. Do you want to clarify that any further?
That's correct. I mean, there are certain things, certain aspects of housing that would be carved out from the reach of CCPA. The other thing that I want to mention is that to the extent that there are certain use cases that are not specifically clear within the regulations as they are, that you as the board would like to specifically ensure are not covered by the regulations, we would take that direction and draft some language for you all to consider at the next meeting. Just in case there are issues like this where a lot of these things involve a fact and context specific analysis where we cannot literally articulate every decision that would be in versus out. It's very much dependent upon those things. But if there are entire use cases that you all have specific concerns about, we can take direction on that.
And to that point, Mr. Wirth, for instance, on housing, if you said, actually, we don't want hotel in scope, we could explicitly exempt that out from that definition of housing.
I think a good step would be for housing and healthcare services. If you could provide us, the broader exclusions, so we know what is already excluded, and then if there's something that stands out, we could offer direction on adding more to it. Does that work?
Absolutely. In fact, what I would offer up, in fact, is that I think financial and lending services, housing, and healthcare services are three categories where there's sort of exemptions blended in.
Just put them all together.
And I think we could add color to all three.
Thank you. Yes, I'm apologizing, Mr. Lieber. You move, and I always think you want to talk.
No,
I'm always putting you on this, and you're always looking at Mr. McTaggart. Mr. McTaggart, go ahead.
Okay, thanks. This is back where it gets into both, do you need to conduct a risk assessment? Do you get the right to opt out? And kind of going back to what Mr. Wirth just said, this one's really concerning for me because the way, and you've dealt with it a little bit in the beginning when you talk about the access to, the way it's worded, I feel like this is what goes back to the advertising, which has got nothing to do with behavioral advertising. But if you use ADM, which you have to because that's the way the ads work, to show a hotel ad, to show an airline ad, to show an education, opportunity, this gets into you're going to need to do a risk assessment just because of the nature of the business you're in, and you're going to need to offer the opt-out of the actual ads. That I don't think can work because, you're going to be using ADM because even if we change the definition of ADM to have the human involvement, still somebody's going to buy an ad on Google or whatever and say, I want to place it next to these keywords or whatever, and that's kind of the way these things work. And that won't fly here. So I think we really need to, of course, we all know where we want to get to. We want to say, like, if you're, to your point, 60,000 denials a day from some doctor who's just, a month, whatever, sitting there, hitting delete, deny, that's clearly got to be covered. And so I have a big issue around advertising, things like maps. My mapping function tells me which direction to go, and it real time routes me around traffic and stuff like that. And is that my access to the hospital? Where I'm going. So I think things like that are, that shouldn't result in a risk assessment just because I'm telling you where to go. And it shouldn't result in me being able to opt out of that. So most of these things, for the deletion, I thought there was a really good comment from one firm that said, look, we had 660 million work assignments last year in California. And not only would this mean that every person's assignment of work would be a significant decision, but everybody who didn't get the job, it's a significant decision. So you have 660 million times however many people are working at any given hour. And that can't be a significant decision. I kind of agree. Like if someone's close to the grocery store and they get the job because they're close to it, and then the firm has to go through and say that, how it wasn't a discriminatory situation. So I think narrowing this really should be around those significant legal decisions, which there's a big difference between not getting a job and not getting the pick up from DoorDash to go to the next place. And I think one of my general comments is a lot of the comments, while well-intentioned, are seeking to use privacy to regulate like workforce law, employment law, and other areas of law that people are concerned about, all of which are very valid. I mean, no one wants to be in a unfairly surveilled workplace, but this is a privacy statute, so I think this definition of significant decision absolutely needs to be scaled back. And especially, I think it needs to be really tied to the actual denial of, the job that you were looking for, the loan you were looking for. And I think we need to spend a lot of time on Mr. Wirth's comment so that when you call the hotel and it's full, that's not a significant decision.
Thank you. Mr. Liebert?
All good points. So I'm convinced that these approaches that you're giving us these options for of deleting various things like insurance, et cetera, make sense. I'm not sure yet about the employment or independent contracting opportunities category. So I'd like to kind of learn more about that. And then I also think what Board Member Worthy said in terms of getting more information regarding those other categories makes sense. But the big picture here is, thank you for bringing these ways to constrain the number of use cases that would be having to deal with these issues. So I think that's a good development, and I hope we've given you some good direction.
Thank you, Mr. Liebert. So if in listening, I don't want to miss anything. So I think I've heard, certainly from Mr. McTaggart, delete access to, and delete insurance, and maybe, and from Mr. Worth, specificity on some of these other categories. And what am I missing?
Actually, I didn't make one point that I should for all of us, and that is the alternative 5, deleting or narrowing essential goods or services, is a huge one, right? I think firms perhaps like Amazon and others had some legitimate concerns about what that might mean for their business models, and should be quite pleased at the concept that we would be deleting or narrowing that as well.
Yeah, I think I just want to confirm what you just said, that we're going to take this page, so those that are deleted are removed. And we're going to take those 3 other categories and get better information about what's really already excluded in those buckets, and then decide if there's more work to do on those.
Thank you, Mr. Worth. When you say these, do you mean the ones we've discussed, or do you include all the ones that have been marked for possible deletion? Just because I would need to understand Mr. Liebert's comment about work allocation. Were you saying we should just go ahead and delete it? I thought you were saying...
Yes, I don't think we should do that one. I see that in the same category of needing more information, if that's okay with you, because I just don't know the implications of that. I know that labor groups might have some important input on that as well.
Thank you. Mr. McTaggart,
my point would be, I would delete everything you have here that you marked delete. I would add something to really clarify about the advertising side of things, that just advertising doesn't create a risk assessment or a opt-out, as long as it's done, first party. And to Mr. Liebert's point, I agree kind of conceptually. It's a question of where the line is. Clearly, I don't get the job because they didn't even look at my resume. They just said, oh, he's got the wrong sounding name. Everybody agrees that's egregious. And we can't kill the gig economy. I mean, it's one of those things, that ship has sailed. And we got to be able to not pretend that we're going to, through a privacy statute, come address how the delivery person or the Uber or Lyft driver gets assigned to the closest task, or, use that algorithm. I think there's a lot of employment law that can govern it, and frankly, this is where the legislature should get involved if it's not. But we we're talking about risks to privacy, not employment law.
Thank you, Mr. McTaggart. Broadly, I certainly agree that this just requires a little bit more attention from the board, absolutely. One of the things that I heard in public comment when I attended the info sessions, for example, and I've read in the transcript from gig workers, is being dropped entirely from the platform with no notice and no understanding of what information might have been involved in that decision. And that's something that, for me, I'll just say right here, I haven't thought about this. I probably shouldn't say it in a public meeting. I haven't thought it through myself, but they don't even know if that decision relied on personal information. And so that, to me, seems like the kind of use case that we might want to consider more closely. But I'm unsure. I do want to say a little word about what is a privacy issue. It is something that also is just throughout the comments, people would say, that's not a privacy issue, that's a privacy issue. And probably because it just seemed obvious to them one way or the other. Let's be really clear. Privacy is definitely about creepy, which is something that's come up in the board before, but it's about much, much more serious things too. And the creepy doesn't really matter. Who cares if something's creepy? What we care about is the effects on people, the interaction with privacy, with personal information to make decisions that violate civil rights. That is very much a privacy issue, and that is not me saying that. That is a lot of courts saying that. discrimination in various forms based on characteristics of a person, those are privacy issues, and discrimination is reflected in almost every other privacy statute, comprehensive privacy statute, if not. Location, for example, I think Mr. McTaggart's example of, the tracking of the location is a really good one and a rich one for us to consider. Depending on the circumstances, if you're tracking somebody to a reproductive health center and you are an abusive partner of the person going to the reproductive health center, or you are a member of a community that doesn't want that person to gain critical information about their body or about their sexuality, that is a privacy issue. That relates to deeply intimate personal information about a person being used to make some kind of, some action against them. Why do we care about what books you read? Why do we even care about what books you read? We care about what books you read or other things that you read because the Supreme Court has reflected the societal value that one of the most foundational First Amendment rights is to be able to receive information in a private fashion so that people can consider information and consider ideas. And the court has been very clear that this First Amendment protection is undergirded by the privacy. So I just want us to be clear that privacy is not necessarily just what, somebody thinks it is in the moment. And in my view, we need to go by our statute, which is really centered on personal information. And we absolutely need to be, judicious in how we sort of use our authority, and to recognize that because privacy is what privacy is, and it's, it has these many dimensions, that of course our partners in the legislature, of course our partners in other agencies, they will have work, for example, labor, right? There are going to be issues that will touch on privacy as well, and we have to be really clear-eyed and thoughtful about that. But it doesn't mean that something isn't a privacy issue because it doesn't say the word privacy.
Yeah, thank you for that comment. I've oftentimes said in the journey that privacy is the wrong word for privacy because I think, in so many respects, how your information is used is a really fundamental question for democracy, for the survival of democracy. And I couldn't agree more. I think my issue here is that, your example, which is a great one, really depends on the information going somewhere that you, the user, didn't want it to go. I'm using the mapping function. I kind of know that the mapping company needs to know where I'm going. The question is, once I've gotten to the reproductive clinic, I don't expect them to sell it. And that's why the whole architecture of CPRA, CCPA was aimed at giving the users control over their own information. Consumers get control of their own information. The abusive partner should not get that. You should be absolutely sure that when you're dealing with a particular service, a dating service, whatever, religious service, that information stays between you and the service. And that's why that whole approach is here. What's concerning about this is suddenly we're saying that the firm that's providing you that service, that you know is providing you the service, that you know is getting you around the traffic, somehow that I should either have the right to opt out because it's a significant decision, or they have to do a risk assessment. And that I don't agree with. It's what they do with the information. And that's I think what we're all kind of, I think, triangulating on. But I think it's what happens to the information. It's not the fact that it got processed.
Thank you, Mr. McTaggart. How are people feeling about lunch? Let me back up first. Oh boy, have I messed up because I've now mentioned lunch, and my intent was to first ask staff if they felt like they had enough information about these alternatives.
Yeah, I'd like to take the opportunity to just try to summarize back to what I think is the consensus.
Everybody's going to think about lunch.
And then we can talk about lunch.
I apologize. I'm making all kinds of bad decisions today.
Okay, very good. So what I've heard from the discussion and what I think we're prepared to come back with text of would be a version of this significant decision definition that removes the words access to, that removes potentially all of the alternatives that were presented here, all 5 of those. I recognize there's been discussion, though, and a little bit of debate around allocation or assignment of work. I guess I just want to point one thing out. When folks are asking for additional information, technically, if we leave it in here and we go out for public comment again, at least under the APA, comments are supposed to be constrained to things that are changing from the last version and not necessarily staying the same from before. It's not to say we wouldn't get comments on these if we're asking for them, and we could. At the same time, another way to approach it would be to eliminate it, see what the comments are to that elimination. So I guess I just want clarity. Are we eliminating it and asking for more comments, or are we keeping it in and asking for more comments?
So my understanding was that we would be looking at use cases, which may result in deletion or may result in edits to the language, which would then provoke comments. But am I misunderstanding you, Mr. Liebert and Mr. Worth, because these were, okay.
I think what I heard from you on financial or lending service, I'm trying to read sideways, that there's a broader set of restrictions around that we don't have here. And then we talked about, because I mentioned housing and healthcare services, and you previously had mentioned that first one. And then I think board member brought up adding that fourth category on the employment to a set of terms that you're going to give us more information about how they really play out, because there's other rules that impact how broad those words look to me. That's what I was asking for. So, and by the way, you're going to get comments on whatever people want to comment on. So,
yeah, Mr. Liebert.
I just want to make sure, I want to keep it in for now, the employment or independent contracting opportunities to get those comments, but also to get information from staff about use cases that would help us understand next time we visit this, whether or not we think it should be taken out.
I think the process point was just that we have to make some kind of a change to get a comment, but I think we can work with that. I really do. Okay. Mr. McTaggart, yeah, go ahead.
Mr. Lillard, can I suggest that we bifurcate and we sort of have one is like the more permanent job situation, and then one is the temporary, like little, DoorDash, Uber, Lyft kind of situation. And I feel like if we do, and we can play with that, that to me, I think might get more at what Mr. Lieber's talking about, I think.
Let's see. Okay, so, the provision that we called out from what is a list of sort of employment decisions is allocation or assignment of work. My understanding was that was what we were kind of focused on, not necessarily compensation, promotion, demotion, suspension, or termination. So if I'm hearing correctly, I just want to make sure I'm clear on what we should be doing from the staff level. We could, for instance, try to go through comments and surface to you all at the next meeting sort of where comments have raised issues and examples around allocation of assignment of work. If that would be helpful. When I hear use cases, I mean, we could try to do further research for you all, but I just want to make sure we're...
Can I suggest, I think some of the comments felt different. Some of the labor comments were like, our staff are feeling terrible because they have to be on one side of town, then on the other, and they don't have enough travel time, or the nurses were not assigned properly to the workforce. That feels like one set of issues with kind of permanent labor, and then the other is sort of the gig economy of the drivers who are showing up somewhere. And so I don't know. I'll throw that out there. There may be a there.
Mr. Worth?
Yeah, if it helps, Mr. I'll be really clear on housing and healthcare services. I just think those are way too broad.
Yeah.
Right?
Yeah.
So however we need to, if you can show me it's just not as broad as you think for these reasons, or let's come up with language that tightens them up if there's no help.
Yeah, for those three I mentioned before that would remain, we would certainly offer clarifying definitions.
Thank you. Mr. Liebert, are you happy with that?
I'm just confused with that.
Okay, well, yeah.
Yeah, so how are we, I understand the point that you made. And then the point that you made, Madam Chair, is that if we alter that will create a commentary process.
As I understood what Mr. Laird has just said, yeah, alter, and that could be by adding examples. That could be by us having a chance to talk about it and revising the language to some degree. Or it could be by deleting it.
Yeah, what would you recommend?
Oh, actually, one thing I'm going to recommend, although I was going to force you all to figure this out before lunch, is if we could come back, perhaps from a staff level, sort of a quick
about
proposal.
That. Sure.
And then the last thing I just want to acknowledge, though, before we break, is the issue Mr. McTaggart raised around at the beginning of the definition, still adding clarity to provision or denial of, to potentially scope out advertising or make clear sort of where that threshold is, and it's not necessarily the use of a map or an advertisement leading up to a decision. So trying to add some clarity and confining the definition further there as well.
Okay. Okay, wonderful.
Addressing the advertising thing too.
That's exactly what I meant, yep.
All right. Thank you. This has been incredibly helpful. For our advisors, has been incredibly helpful. I think that we have made some real substantive progress. I hope that it's been helpful to you for us to talk through these issues and give you our what we would like to see next. With that, let's take a break for lunch. I suggest that we plan to come back at 1 o'clock. That would be 45 minutes, or we can, does that work? Okay, fantastic. Thanks, everybody. The Zoom will remain open if you're on the Zoom, but we won't come back before 1 o'clock. Thank you. Wonderful. Welcome back, everyone. Now that we are all fed and hydrated, let's go ahead and dive back in. If you are joining us for the first time now, we are working through agenda item number 3 on draft regulations, and we are on, as I believe, slide number 9 on the modification to proposed rule regulations PowerPoint and the materials for today. And with that, I'd like to turn it back over to the legal division team.
And before we proceed to issue number 3, the slide currently prepared, just as I committed earlier, I just want to restate one more time to make sure we align with the board's direction in terms of issue 2, significant decision, what our plan is from the staff level. 3 things we're looking to do essentially: accept the alternatives 1, 2, 3, and 5 in a proposed modified text, add further definitions, explanation to financial lending services, housing, and healthcare services, further explore alternatives with allocation or assignment of work, including exploring potentially a division between sort of permanent employee allocation or assignment of work versus the example of gig workers or independent contractors, as well as supporting that with potential examples and use cases to add some color to that issue for the board to consider when they see this text again. And then finally, to further revise the opening of the definition to make clear that advertising would not be included as part of the provision or denial of one of these significant decisions.
Thank you. That sounds correct and like a clear summary to me. Yeah, Mr. McTaggart.
Thank you. It sounded correct to me. The only thing I would say is there were a number of insurance submissions, which frankly were quite long in the comments, and I went through them, but I can't say that I'm an expert in insurance law. So sometimes they raise stuff saying this is, just the intersection between whatever the Insurance Act is and our act. And so maybe there needs to be some, clarification. If the word insurance, but I don't know. I'm just throwing that out there.
I will note that's one that's actually proposed as a potential deletion. And so if we delete, to your point, that would actually, I think, resolve that issue in this context.
Thank you, Mr. Laird.
We're deleting everything that you marked as delete, right?
Yes.
Correct. Okay.
With the exception of allocation or assignment of work, we're going to explore an alternative. Yeah.
Wonderful. Thank you.
All right. Very good. So moving on to issue number 3, behavioral advertising threshold. I am going to once again pass it along to my esteemed colleagues.
Okay. My colleague, Ms. Shake, already covered some of this in the context of discussing other issues among the board, but just to refresh when we say behavioral advertising thresholds, we're talking about the language in both the risk assessment article and the ADMT article. The regulations as currently drafted would require a business that profiles a consumer for behavioral advertising. That includes first party and cross context. It does not include contextual advertising, but it would require businesses engaged in that kind of profiling to both conduct a risk assessment and to comply with ADMT requirements. The inclusion of the threshold was based on direction from the board and had been recommended by the new rule subcommittee. And as you all know, the threshold has drawn significant feedback from the public. Consumer advocacy groups have supported it, particularly the opt-out requirement to address first-party advertising by businesses. However, small businesses and industry groups have strongly objected to it, in part because of concerns that the threshold would negatively impact their ability to advertise to their own customers. Next slide, please. The options on this slide are leave the threshold as is for risk assessments and automated decision-making technology, or remove the threshold for risk assessments and automated decision-making technology. So we'll pause here for the board's discussion of those alternatives.
Thank you. Did you have any explication of the choice here for us beyond this? Or, I mean, I guess it's very simple. It's in or out. Okay, wonderful. Thank you. Mr. Worth, Mr. McTaggart? Okay.
Yeah, I mean, this kind of goes back to that earlier discussion. Walk me through what happens if you remove this. It just seems hard for me to wrap my head around, like, we can just take something out and we're good with it. And I would like to, I do appreciate, though, hearing from staff what your preference is, too. There's only two choices here, though.
Sure. So staff's recommendation would be to simplify implementation at this time, deleting the profiling for behavioral advertising threshold from both articles. This would mean that businesses no longer have the requirements. If they're engaging in this particular kind of profiling, they would not have to conduct a risk assessment for this particular kind of profiling, nor would they have the ADMT obligations of providing a pre-use notice, providing an opt-out right, or providing access to ADMT upon request.
One thing to clarify is, of course, the concept of selling or sharing would still be in the law. So, like, it would still be in the risk assessment requirements. And, of course, the CCPA provides consumers with the ability to opt out of selling or sharing. So that would stay the same and potentially still remain in risk assessments.
Thank you. Before we move on, did you have comments on Mr. Worth's, the second part of Mr. Worth's question as to what would be the effect of the removal on the regulatory framework?
Yeah, I think in terms of the framework, if you don't mind, sorry. Essentially, this is one of multiple categories of automated decision-making technology, and then also triggers for risk assessments that was included. And so if you think about it, I look at it as a list of topics we included. This would just remove one of those items from the list. And so the rest remains intact, but this essentially would come out of this regulatory scheme. The other thing I just want to emphasize at this point that really goes for all of these proposals and anything we're potentially walking back, that doesn't eliminate this board's ability to revisit these issues, to reconsider adding these at a future date, to further research and observe what's happening in the marketplace. And so certainly anything that the board decides to scale back at this time, I would recommend we continue to monitor as an agency.
Thank you, Mr. Laird. Mr. McTaggart? Mr. Liebert, are you?
I'll give you time to look. I think this is a big deal, and that all of those folks who wrote in should recognize this as a really big deal, and that the agency is listening and paying real attention to these concerns. So I ultimately am supportive of removing it, and applaud the staff for the work that they did in this regard as well. Thanks.
Thank you. Are you ready, Mr. McTaggart?
Thanks. And I want to apologize to you. I think I did support this a couple of, meetings ago, and at the time, what I realized I was just conflating behavioral advertising with cross-context behavioral advertising, and so, which maybe many of us did, but it is a new term, so I understand the comments, and I think you just answered it, but one question is, so if we just change it to cross-context behavioral advertising, but the consumer already has the right to opt out of that under CCPA, and so theoretically, if they've exercised their rights, none of that's going on, so I think that's fine. And then the other question, I saw one comment in the comments about the B2 for the risk assessment and profiling a consumer through systematic observation of publicly accessible place. And I think my answer is going to be, you're going to tell me that it's in profiling, but I think the comment that I read from one of the commenters was, look, if we're just, it's basically security cameras, we're not doing stuff with people, but that's not, then that wouldn't fall into the profiling, right?
That's actually a separate threshold, and my colleague, Ms. Shake, will be addressing the public profiling threshold next.
Can I ask, Mr. McTaggart, with regards to the well, actually, I apologize, Mr. McTaggart, I think it was a question for staff. This hadn't occurred to me. Thank you, Mr. McTaggart, for pulling that out of the comments. So if we were to strike the whole thing, including cross-context behavioral advertising, that would mean that cross-context behavioral advertising also wouldn't trigger a risk assessment.
No, actually, when we're talking about the profiling for behavioral advertising threshold, we also added a separate definition of behavioral advertising to the definition section. So if we take out the profiling for behavioral advertising threshold, we would also take out that definition of behavioral advertising. The rest of the existing framework within CCPA and the existing regulations about opting out of cross-context behavioral advertising, that would still remain as is.
Okay, wonderful. Thank you very much. Thank you for clarifying that. I'd like to echo Mr. Liebert's comment that very much appreciating staff's careful attention to the comments and to, we've gotten lots of comments on this in our board meetings as well. We've had a lot of public engagement. I feel bound to say again, this isn't a question of authority. This is the question of how far we want to extend this authority at this time. I absolutely agree with Mr. Liebert that this is a big deal. If the board has consensus to remove this now, it's a big deal, and it is a sign that staff and the board have been very responsive to the comments. And I would hope that that would be recognized. So thank you very much for that. Mr. Worth, did anybody else want to opine on this, or are we on? Do we have consensus to go ahead with the alternative? Okay, let's move on to issue number 4.
Thank you. So turning now to issue 4, if we could go to the next slide, please. Thank you. So this issue 4 addresses the other extensive profiling thresholds that are in the framework. So we'll start on this slide with work or educational profiling, and that generally addresses profiling of job or educational program applicants, students, employees, or independent contractors through systematic observation in workplace or educational settings. If a business is engaged in this type of profiling under the proposed regulations, it would be required to conduct a risk assessment and to provide pre-use notice, opt-out, and access mechanisms to affected consumers. Next slide, please. Thank you. With respect to public profiling, this threshold addresses profiling of a consumer through systematic observation of a publicly accessible place. And similarly to worker educational profiling, a business conducting this would be subject to risk assessment and the notice notice, opt-out, and access requirements in the ADMT framework. Next slide, please. Thank you. And so during the comment period, we did receive comments on these thresholds. Consumer advocacy organizations supported the inclusion of the worker educational profiling threshold to protect consumers in these contexts. We also, of course, had industry commenters who were concerned about the worker educational profiling threshold stifling their ability to manage their workers, implement efficiencies, and chill innovations. Those commenters also raised concerns that the public profiling threshold could capture everyday activities, such as tools to map fitness routes, and they recommended either removing this threshold or clarifying that it does not encompass services that consumers enable to record their own movements. So essentially, a consumer is turning on the mapping function, or narrowing the types of publicly available places that are in scope of the definition. So we received a variety of comments on this threshold. Now turning to the actual slide, again, it's similar to what was presented on the prior issue. The board, of course, can always leave these thresholds as they are. They could also remove these thresholds from the risk assessment framework, from the ADMT framework, or from both. And again, as we've said throughout this presentation, these are just a couple options before the board. Of course, to the extent that there's wordsmithing that you prefer or anything like that, staff is absolutely open to that type of feedback and is here for questions. I'll pause here.
Thank you. I have a question. I don't know if it's quick, which is, I was just wondering, based on how the comments and how they sort of, how they landed, why we only have the two options here, the yes or the no, as opposed to, for example, as Mr. Worth pointed out for the earlier conversation, more information about or more understanding of what some of these would mean.
Absolutely. Some of it is just the nature of the slide. We didn't want to provide like many formulations on one slide, so we were trying to simplify it just on the slide itself. But again, like other options that were provided in comments were narrowing definitions or narrowing the scope of the threshold, which is always available. And to the extent the board is interested in exploring those options, we can provide a bit more tailored feedback on that. And then about the kind of taking the like bird's eye view of where we are with these comments on these thresholds is, you know, we really got a variety of comments here. We have consumers and consumer advocacy groups who are talking about the concerns they have about this type of profiling, particularly in the workplace setting. And then, of course, you have businesses and industry commenters saying, you know, but these technologies also have very beneficial uses to businesses, to the public. And so we have a wide variety of comments that are really saying there are risks to these uses, there are benefits to these uses. And so that's why one of the kind of foundational questions for the board right now is, you know, given this context from across the comments, is this, and considering these, the balance of the benefits and risks presented in the comments, is this something that the board is interested in pursuing or holding back for now?
Wonderful, thank you. You know, I find work in educational profiling to be potentially very profoundly important, depending on what's happening, you know. And I read the comments when you know, I absolutely was sympathetic to businesses' concerns here about, you know, some of the basic sort of functions that they need to undertake, and things that are rightly within the prerogative of the employer. And was also very sensitive to some of the concerns from workers, you know, where things just may be going way well outside of that and directly becoming a concern about privacy, dignity, autonomy, et cetera. So for my part, I think this is one of those situations where, I would appreciate a little more information on use cases, I think. So we've got Mr. Worth, we have Mr. McTaggart, and we have Mr. Liebert. No.
I liked what you just asked.
Okay, thank you.
Well, I actually was going to use a use case to understand this better. This could be a really bad example, so don't laugh out loud if it is. If I'm applying to like a large transportation company to be a truck driver, and I check on my application, I check a box that says I have a previous DUI, and their system kicks my application out without anybody seeing it because I checked that box. Is that profiling in this definition?
Sorry, we're both working on this together, so we're like, who's saying it? I think in that context, we're thinking about the potential overlap between profiling and significant decisions. So obviously the concerns about workplace and educational profiling and significant decisions that impact hiring decisions and allocation and assignment of work and compensation and those sorts of things are covered by this broader framework. I think the specific question that you were asking about would be covered by the significant decision threshold.
All right, Mr. McTaggart?
Yeah, I had a question. So going back to the comment of walking by the, you know, billboard and it flashes and it takes a picture of you, whatever. So profiling versus the security camera in the airport, which may have a function where it could search for a face print if it turns out the cops are like, whoa, we got a bad guy here. How does the that profiling, the public profiling, where do you think the line sits there because of the definition of profiling?
Absolutely. So it would have, thank you. There would have to actually be some sort of, the definition of profiling in the statute means there actually has to be an evaluation of the consumer that's happening via the automated processing. And so, for instance, a CCTV, like a video camera, it depends on, this is going to be a frustrating lawyerly answer, but it really depends on how the business is attempting to use it. Like, are they using it with potentially even like a mix of facial recognition to determine, you know, is this someone who's a safety threat? Because that's an evaluation of the consumer. But if there are, and I know I've said this with other thresholds, but if there are things that board members are concerned, or, this is not the type of use case that we are trying to get to, we can always draft a more tailored carve-out within the definition or within the threshold to make sure that, for instance, if you do not want just the general use of a security camera in a retail store to be covered, we can always carve that out.
Can I maybe ask my colleague, would it be fair to say the billboard that takes your picture, but then determines based on something about your picture that it wants to advertise something to you specifically, right? That would be profiling at that point. That would be covered here. But then the point I want to make is there are the exceptions as well. So then the part of the concept is that would be covered. But then if the same camera is being used, to your point, to alert for known terrorists or something of that nature, that would fall under our safety and fraud exception if that was the sole use of it. So it would actually, again, to my colleague's point, it's all use dependent. It depends on how that technology is actually.
If you're advertising to terrorists, then we don't know. We don't know what to do.
I'd like to echo the chair's comment. I think we should get a little more, information on this. And, I said many times, and I think this is in the significant decision part, but, we all actually have an interest in knowing whether the delivery driver is being monitored. I mean, you all kind of want that at some level to make sure that the person's not speeding, not going crazy, not blowing through stop signs. So that's kind of a good societal good. But of course, the delivery driver deserves to know what's happening. But I'm not sure that we need to create a situation where the delivery driver can opt out of it. And this is where I get really nervous that we're a privacy statute and we're all of a sudden getting into sort of employment, work rules, which I feel like they're super important. It's just maybe not the venue here. So I think when you come back with the more granular sort of between this work and public profiling, maybe we could just keep that kind of approach, those questions in mind.
Thank you. So, Mr. McTaggart, so your comment applies to both worker educational profiling trigger and the public profiling trigger. We're talking about those together. I thought that was me for a second.
I think that's an aircraft.
Very low aircraft. I thought that was my microphone. Oh gosh, I made a joke about a terrorist. Bad idea. Does the board have consensus around that request? Okay, Mr. Liebert? Okay, wonderful. And does that provide the staff guidance for us?
And I just want to make sure we understand the guidance. Is it to think through these thresholds based on the public comments, based on the feedback today, with potential use cases, and for the board to consider in terms of determining the scope of what's in and out?
Precisely. Wonderful. Thank you. I think that brings us back to training, and maybe we are in a better place to talk about it in terms of our understanding.
Can we just ask one clarifying question of the board, which is if you all have certain use cases that you want to make clear would be in or would be out, because we can also modify what these thresholds actually mean. So if there are certain things that you want to be clear should not be included because you all kind of agree that they shouldn't, or you want to be clear that certain things are included, we would love to have that direction too, so that we can kind of target our assessment about use cases that would then be in or out as well.
Thank you. Mr. McTaggart.
My quick reaction to that says, in terms of workplace, there's a ton of software, I think, that is just what I would call, has come at this point to be sort of normal. So it might be your card key getting into the building tells you what time you showed up. It might be the monitor in the car or the truck that shows how fast you're driving. It might be, some kind of an attendance sort of situation. And I know these are very hot topics for labor, and I'm not trying to, again, diminish them, but I don't know that we want to make it transparent, but I feel like they're not particularly risky, and they're not, it's going to be very difficult to create a situation where the employee gets to opt out of the use of these things in this day and age. However, there should be transparency, that employees should know they're being surveilled. Like, if that's really important, And that feels very different than, you know, let's figure out which woman's about to get pregnant and fire her before she's even gotten pregnant. That's obviously super creepy. And then with the public, same sort of thing, you know, the CCTV that doesn't do anything in an airport, no big deal. And then you walk into the store and it facial matches you to, you know, some database and says you're a customer that we should really pay attention to versus you're not. That feels really creepy. So those types of things, for me, are my first reaction.
Thank you. Just to clarify, just what I'm hearing back from you. So if we're talking about defining the threshold, it sounds like what you want to do is something a little bit different, which is, that you would want things like card key access, checking in, clocking in and out, speed of driving, things like that. All of those technologies would be in as a threshold of profiling, worker educational profiling, but what your proposal would do would actually not be to further modify the definition under the threshold, but it would be to carve out the opt-out requirement for worker educational profiling. So it seems to me like you would be in, it would be kind of a between, not leave as is, not an alternative, but saying for those types of technologies, those would be in as worker educational profiling, but you wouldn't provide an opt-out from them. You would just have the notice and access.
This is sort of like I can describe the destination and how you get there is sort of how you guys get there. But I think that what I'm trying to say is I don't feel like it's tenable to have these things be, you know, opt out, even though I know it's going to be contentious to say that. But that doesn't mean that the employee or the worker or whoever does it shouldn't know that, you know, this stuff's being monitored, you know, about their behavior at work.
Mm-hmm. What about with regard to risk assessment? So if a business is using this kind of, you know, technology to do those things as described, do you think that it warrants a business conducting a risk assessment?
Well, again, for me, I come back to the language that is it a fundamental risk to the privacy and security of consumers, right? And consumers are employees, obviously. But again, I don't think swiping into the office or to the place to show, you know, I used my card key, I went out 3 times, I came back in 3 times. That to me is just, it's hard to know that that's a privacy risk. And again, they're making sure I don't speed on the freeway or that I take my breaks. That doesn't feel like that's a privacy risk. It depends what they're doing with it. If they're then selling it to some insurance company to make sure I can't go get a job somewhere else because I sped 3 times, maybe I want to know about that. So it's not so much the activity, it's what's done with the data. Sorry, I'm not being very clear, but that's kind of where I'm coming at it.
Yeah, I think the picture you're drawing is quite clear, Mr. McTaggart, but I'm not sure if staff need more indication to help think about it. Yeah.
I'm going to give you an example. My computer has a face print to open it. That I don't think necessarily means they got to do a risk assessment, but yeah, if they're selling my face print, for sure. You know, if Lenovo is selling it, then yeah. So it's really, again, for me, it's not so much the activity, it's what happens to the data, which is actually the whole way CCPA and CDRA is structured.
And maybe that was the point I was going to make is, I mean, some of the things I think you're suggesting are covered by other aspects of the CCPA already and or in other components of this draft regulations. So anyways, I don't necessarily have an answer to that besides to point out then if we're not going to do opt-out or access or pre-use notice for those things, then that does start to lean towards removing this as a threshold.
Mr. Laird, maybe what could happen when you bring it back is you could say, well, the reason we're recommending removing, because it kind of looks big, is because it's covered here, 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 and here.
Okay.
You know, and that would be helpful. And then, you know, it's already done. So we're solving for nothing here.
One thing I just wanted to point out, just because you were mentioning, you know, maybe not having a risk assessment associated with the use of clocking in or out or security-related things. If you're processing a biometric, if you're processing SPI, that is a trigger for a risk assessment, regardless of these particular profiling thresholds. So I just want to be clear about that. Just like we were talking about before with the profiling for behavioral advertising, that's entirely separate from the threshold of having to conduct a risk assessment if you're selling or sharing personal information. So just to be clear about how that would
You're
work
right.
together.
The computer company should say, this is why I'm not selling it, you know, should know that they're not.
Mm-hmm.
So, yes, I'm sorry, you're right.
Okay, thank you, Mr. McTaggart. Other comments? No? Mr. Liebert? No? Staff, do you feel, or legal division team, do you feel like you have a sense of this one?
Yeah, I think so. I think we'll come back with a proposal and or supplemental explanation of
Great. Wonderful.
options.
Thank you. I believe that brings us to issue number 5, which is actually where we started. And yeah, okay, thank you. Please take it away.
Thank you. And just to spare everyone, because I know that we've already provided a background on the training threshold, why don't we skip ahead to 2 slides of the alternative presented for training? Thank you. Yeah. All right. Just to refresh for members of the public who might be tuning in now, there are a few options for the board, and again, non-exhaustive options, with how to handle the training threshold. Of course, the board can always leave things as is. They could narrow the threshold by adding some sort of limiting standard, so it's not technologies that are capable of being used for certain purposes, but narrowing the to potentially just uses. And then there's also, of course, the option of just removing it from the ADMT framework, removing it from the risk assessment framework, or removing it from both. And so we're happy to discuss how the board could approach this and answer any questions, but we'll pause here for now.
Thank you. If you're prepared to talk about this, I would be grateful to hear a little bit more about the range of viewpoints in the comments on these issues. Again, I read through them and I feel like I have a sense of it, but I don't have the deep attention to it.
Absolutely. And again, obviously there was the letter writing campaign that was just generally supportive of the regulations. Then we have industry commenters who had a variety of feedback on the threshold. Commenters requested removing the threshold, and some of the reasoning was that they think that the processing to train AI or ADMT is low risk. Alternatively, commenters also recommended narrowing it so that it only applies to training systems that the business actually intends to be used for any of the purposes outlined in the thresholds, or that are reasonably likely to be used for those purposes. And so that's really, like, at a high level, what we've seen in the comments is just general support for the concept. And then from industry commenters, we've seen a request to either remove it or to narrow the threshold away from the capable of being used standard.
Thank you. One more question, sorry, is that these would apply prospectively. Is that correct?
Yeah, for both sets of requirements, it would be prospective. So risk assessments, risk assessments, there's a bit of a nuance, but when we're talking about the pre-use notice of providing the notice and the opt-out, that would be on a go-forward basis.
A go-forward basis, yeah. Okay, thank you. Yeah, Mr. McTaggart.
Okay, so we've removed the large language models from the opt-out, but it's still in there for the risk assessment?
Actually, large language models are not subject to the opt-out.
We removed it.
Oh, I'm sorry, I misheard. I apologize. Yes, so they're not subject to the opt-out. There would only be a risk assessment required under the proposed regulations, and that could always be removed.
And so if significant decision has been scaled back, that has a huge impact on the opt-out, obviously. So then you're saying I get to opt out for anything that establishes my identity. And I guess I'm thinking about my phone opening up when I look at it, and that I guess I can opt out by using it,
Well, importantly, this is about training the ADMT that's doing these functions. So it's your ability to opt out of your phone using your image to further train its model to then do one of these things. Or I guess, yeah.
I'm just thinking that the line between training and use is kind of blurred because they'll be using it to train it to kind of make it better the whole time.
Yeah, go ahead.
Oh, yes. So yes, the concept here is for consumers who are potentially comfortable with using their face to open their phone, or for a variety of purposes, who may not nonetheless be actually comfortable with the use of it for training those models, because of the risk of re-identification if it's being used to train other models. That's how this is supposed to work, is you could opt out of the additional training use of your information.
So that could be like do I want to send feedback to Apple? No, I don't. Okay, I'm just trying to figure out how this works.
I think it comes up pretty frequently today. It comes up pretty frequently when people use, for example, social media sites, and they are very aware of and happy with the service that the social media site is giving them, and maybe the ads are being served. But if everything is going into a big bucket to train AI, and they haven't had notice of that, and that may be that's a use of a different color, as I understand it for some people. So I think that is how I understood this to operate. And then the policy question is whether we would want to do that.
Can you, I read a lot of the comments on the automated decision, on the training. And so can you refresh me what their main concerns were?
Absolutely. I mean, again, trying to summarize a variety of commenters, I will do a lawyerly caveat here saying, you know, I don't want to misspeak or try to overstate what people are saying. But at a high level, you have a few kind of underlying considerations for the request to narrow the threshold or remove it. And one of the kind of most common themes that we've seen is just the concern about stifling the development of innovative technologies that could benefit consumers, could benefit businesses, and the potential burden on businesses. With respect to the opt-out, there also was a concern about how it could be applied, like how it could actually be implemented. I think on a go-forward basis, makes sense. Retroactively would be difficult. And there are just technical limitations that are apparent to that, and we could address that if the board decides to keep that in.
One of the comments talked about a cardiac, like a pacemaker that wants to keep on giving back feedback to the manufacturer, you know, to update it, and the difficulty if the consumer wanted to opt out of that. So, you know, how do we think about that?
Ultimately, so under the proposed regulations, I guess it would first come down to whether or not that counts as one of the purposes that's actually outlined in when you have to provide an opt-out. And assume, for the purposes of just analysis, like let's just assume it is, then yes, under the proposed regulations, the consumer would be able to opt out. They would get notice that their information would be used for training in this way, and then they would have the ability to opt out of the use of their personal information for training if they did not want it to be used for that.
Thank you. Mr. Worth?
Yeah, I think when we were on this earlier, my proposal was we remove all the green writing and the blue is replaced with, and there's one black word, but the blue is replaced with is using. That was the proposal I had made, if as opposed to taking the whole thing out.
Okay, so
no, you go ahead.
Okay. With respect to the narrowing of the kind of knowledge standard that we were talking about, there is an issue with narrowing it to is currently using. That would create a bit of a conflict between the definition of the threshold and the requirements that attach to that threshold. So specifically with respect to risk assessment, businesses are required to conduct risk assessments before they initiate the processing that's subject to the risk assessment. That's the whole point, is you think through the risks and benefits and mitigate them so that the balances are appropriate before you engage in it. So to have the knowledge standard be that you are already using, that you are already training in this way, that the business is using the AI or ADMT for one of these purposes, creates a kind of conflict with the risk assessment. The other thing that I would point out is that when we're thinking about, when you think about knowledge standards, just having a full awareness of what the board's preference would be in terms of what would be covered, some criteria that one might think about with a knowledge standard to narrow it from capable of being used to something that is more easily kind of assessed about whether a business already is, not only already is engaged in a processing, but if they have, you know, definite plans to use, or they're permitting, or they plan to permit somebody to use, then that could be something that would be in scope. Similarly, if they advertise or market for these purposes, or plan to advertise or market for these purposes, those are also kind of indicators of not just are they already doing it, but do they have plans to do it in the future, which is more concrete than capable of being used.
Right.
And I don't know whether that's something that you would be amenable to. I think the biggest thing is just saying if they're already doing it and that's the only threshold, it does create a bit of a tension with the risk assessment.
What if we did prior to intending to, meaning if I have the capability but I have no intention of doing it, I don't be bothered with this. But if sorry.
Could I just suggest plans to use or is using?
Yeah, you know, but I think what I'm hearing though is you don't want that second part. You don't want to give me the ability to say.
I don't think it hurts if it's an or.
Okay, that's fine.
Right. Because you have to do it before, no matter what. If you're planning, you've got to do it. And if you happen to be using it already when these regulations become final, then you are using it and you need to do risk assessment. Sorry, Phil.
We could write the threshold differently in the risk assessment versus the ADMT portion of these regulations. My point being, for risk assessments, it could be exactly the plans to use, versus in the ADMT, it could be is using, or the or articulation.
Just put it in both. Yeah. Thank you.
And the only other thing we'll flag
Okay.
is that because there's kind of the developer deployer issue, oftentimes it may be that the entity that's developing it, they may not use it themselves, but they may permit others to use it. So I think that's also a concept that we want to incorporate into the knowledge standard. Okay, thanks.
And then my only other, sorry.
Sorry, I just wanted to record Mr. Liebert's nod on this conversation.
And then my only other question goes back to the inclusion of the green, E in the risk assessment. And again, this gets back to me of like, the notion is we're saying it's privacy and security. This is, why are we saying suddenly that the large language model is necessarily?
I had the green removed.
Yeah, but I think you're saying for both, for the risk assessment as well? Okay, yeah.
And we mentioned this earlier in the meeting at the top of the meeting. And that is not something that would structurally change the regulations enormously. Okay?
No, we
All right.
just take out the definition of artificial intelligence, take out every reference to it.
Okay. Are other board members amenable to that? Yes, 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 okay. All right, thank you.
Sorry, I just need to correct myself very briefly. We wouldn't take out every reference to artificial intelligence only because the definition of ADMT also includes technology that can be derived from artificial intelligence, but that's a different issue than the thresholds related to training.
Got it, okay.
Just to summarize, to make sure staff understands the direction here, remove the green language that's currently on the slide when it's in the risk assessment context, and it doesn't appear in the ADMT context, so that would just be removing it. Change knows or should know to some version that captures the concept of plans to use or is using or permitting others to use in some capacity in the risk assessment and ADMT framework. And I just want to make sure that if there was anything else on this topic before we move forward. Those are the two that I've taken away.
I think that's it.
Okay, thank you. All right. Okay. Turning now to the last issue that staff has teed up for board discussion is risk assessment submissions to the agency. If we could move to the next slide. Thank you. So as a refresher for members of the public, the CCPA requires that the agency issue regulations requiring businesses to submit a risk assessment on a regular basis to the agency when their processing of personal information presents significant risks to consumers' privacy. The proposed regulations, as currently drafted, require that a business annually submit to the agency, one, a certification by the business's highest-ranking executive responsible for risk assessment compliance that identifies the months covered by the submission and an attestation by that individual that they've reviewed, understood, and approved the risk assessments, and that the business conducted and documented a risk assessment before initiating any of the processing set forth in the article, as well as an abridged form of each risk assessment that the business has conducted or updated during the submission period with certain information about what needs to be in that abridged form. Lastly, the business would be required to provide an unabridged risk assessment to the agency or California Attorney General upon request, so not on an annual basis, but rather upon request. Now, we did get a lot of comments from industry on this topic that generally requested limiting it to an annual certification requirement or simply removing the annual submission requirement. And turning now to this is the current slide. To really streamline the submission process, particularly for the first set of submissions that the agency would receive, staff, based on these comments, is proposing a higher level version of a risk assessment submission for the board's consideration that would only require a business at the time of submission to only provide the following 6 items in their risk assessment. So it would be their name and contact information, what time period is covered by the submission, how many risk assessments they conducted or updated during the relevant submission period in total, as well as by the final processing thresholds that the board decides upon, what categories of personal information that they processed were subject to the risk assessments, the attestation that the business actually completed the risk assessment by the highest ranking executive responsible for risk assessment compliance, and lastly, a signature and certification that the information provided is true and correct under penalty of perjury and with the additional information on the slide. One thing I do want to make clear, and this is also on the slide, is again, as with the current draft, separate from this annual submission of these 6 categories, the agency and the California Attorney General could still request the full risk assessment upon request, and a business would provide that. So there would be essentially an annual submission of these 6 categories of information, and then upon request, a submission of the full risk assessment.
Thank you. Yes, Mr. Worth.
Is this something you think you'd need to hire somebody to do, or is this something you think the business would just be able to do on their own?
I think with this very streamlined version, it should be something that a business could do on their own. Going through the information here, of course, like business name and contact information, they'll be able to provide relatively easily. The time period they should be aware of, especially if it's on an annual basis, they should be able to provide that information of the month and years that they were doing of their submission period. The number of risk assessments, I would think that the business would have to know, just like how many that they've done. And so they shouldn't necessarily need to outsource it.
Yeah, it's actual risk assessment itself I'm really getting at.
Oh, I'm so sorry.
It's not here, so don't apologize because it's not in here, but that's what I'm thinking about. Like, are we creating a new industry? I'm just trying to anticipate what's the, if I have a 125-person firm, what's the cost I'm going to incur to do this? Any sense?
Yeah, well, I think we're aware that there's different models across industries. Some people have this done completely in-house. I think the regulations are clear enough that any person with familiarity with the business could complete these risk assessments on their own. But we also know for a fact that plenty of businesses also do bring in outside counsel or some sort of consultant to help them with risk assessments. But importantly, this is actually the one part of our proposal that is not sort of pretty new in concept. As mentioned earlier, businesses already operating in Colorado and Europe are doing what are called data privacy impact assessments that largely mirror some of the requirements and the scope of the types of activities we're concerned about here. So it's something that, I just want to kind of make that point that that activity is already underway. So I don't think we'd actually be inventing an industry. I think that industry is already out there to the extent.
Yeah, I mean in the state of California, I was referring to, I'm sorry, but do we have a sense of what the cost is? If it's happening in Colorado, do we know what businesses are paying to do these risk assessments? If not, can we just do a little research and come back?
Do you guys remember? It's in the economic impact assessment. We don't have that at our fingertips, but that the cost of this was certainly considered as part of the proposal.
I should have thought of it. Thank you.
Thank you. Mr. McTaggart.
Just following up, I still think it would be great if Mr. Worth's question, if we could get that answered, just because what the SRIA assumed may be different than what Colorado is actually experiencing. So I think that would be useful if someone could just call around and find out. And notwithstanding my earlier and future issues with risk assessments in general, a couple of points about this slide. I'm hoping we get to a world where if you've done a GDPR risk assessment or another assessment for another jurisdiction, you don't have to do it again. So, so part of this number 1 through 6 could be a 7, we're substituting the French one, or whatever, the European one for us. And then just a couple questions. What's number 3? What do we hope to get out of that? Why is it important that we know how many they've done?
So I'm happy to provide my thinking on it, and of course my colleagues can jump in. I think for us it's helpful, especially with the first set of submissions, to understand how voluminous this is for businesses, like how many are they conducting? What are the thresholds that are triggering the most risk assessments? I think one that's an important data point for the agency to understand, is one threshold really triggering the majority of these risk assessments? Do we need to think about that? And there's actually the second thing, which is about our own requirements as an agency. We are, based on the risk assessment submissions, we have to provide an annual report to the public summarizing them. And this is one data point that we think would be very helpful to the public as a mechanism for transparency of just how many risk assessments are being conducted. But again, these things are for the board. This is absolutely a policy question for the board.
What do you envisage when you say in total and by processing activity thresholds? So I did 4, and what's the second part?
Sure. So, say you're business A, and you've done 5 risk assessments in total. So that would be the first part of it. How many did you do in total? That would be giving us that number. And then it would be saying, okay, we did 1 for selling or sharing. We did 3 for sensitive PI for different processing activities, but they wouldn't tell us what they were. They just tell us how many. And then potentially 1 for whichever, say use of ADMT for significant decision or worker educational profiling. So again, it gives us visibility into what thresholds are triggering the most risk assessments. That allows the agency to continue to refine the regulations as necessary to address risks and burdens on businesses. And as a responsibility to the public under the law, it allows us to give additional transparency to members of the public about what types of activities are occurring, again, at a metrics level.
Thank you. Mr. Woods.
Is staff, that item 7, does that sound reasonable? That if somebody's in Colorado and already providing the assessment information there, that we would accept that?
So we actually have a provision in the current draft that essentially says, if you've already done everything that's in our requirements for another risk assessment, you're good. That risk assessment will carry the day. Our concern would be somebody using a lesser risk assessment that doesn't include certain categories and trying to have that still meet the requirements. These requirements were included for reasons that are stated in the record, and so certainly we want to make this as easy on everybody as possible, but at the same time, we don't want to do it compromising sort of our own values here in this agency in terms of what we think is an important component.
I mean, it'd be a flood to Delaware if they came up with it, right? But do you know now that GDPR and or Colorado would satisfy our conditions? Or if you don't, can you just let me know later?
While they're discussing that, finally, I'll come back in a minute. I was able to find the page in the SRIA that addresses the first-year costs that the economists assessed for risk assessments. And they do say that the average across the scenarios that they were considering was $207 million. They say $207 million as our primary point estimate for the first-year direct cost of risk assessment requirements. And that's on page 58 of the SRIA if you want to take a closer look.
Yeah,
that sounds like that would change.
Yes, that's total.
That would change dramatically if we went with this option. Is that right?
Well, I think this pertained to the overall structure of the risk assessment framework as proposed in the version of the proposed regulations that went out for the 45-day comment. Phil, correct me if I'm wrong here, but modifications that the board proposes to make before the regulations are finalized, there would be an updated Form 399 with the economist revised assessments of what the cost of the regulations in their kind of final proposed form would be.
Okay.
I think it would be helpful if it's not in there, is when they do that revised study, they talk about cost per business. You know, they're obviously making an estimation of how many assessments we're going to get in that number.
Yeah, they would also need to consider at least categories of businesses, because categories of businesses that are multinationals that have been compliant with GDPR for years, and that's a different category of business and a different cost structure than a business for whom this is for which this is completely new. I'm curious about the APA here. So when we say comparable risk assessment, which I really support, and that's been in there a long time, I see no reason to double up your work or for us to would that mean that they would submit or have ready to submit upon request like the one that's labeled Colorado, or that they would put into the California form the same information they'd already collected, or am I just missing the boat on how this would work?
I say this at the risk of not actually looking at the text, which I always like to do to make sure I'm right on this, but I'm pretty sure the understanding would be, at least, if the information is there, it doesn't need to say California. It's that the substance of the risk assessment has been completed.
It says a business may conduct a single risk assessment for a comparable set of processing activities. A comparable set of processing activities that can be addressed by a single risk assessment is a set of similar processing activities that present similar risks to consumers' privacy. And then there's an example about a toy store.
Chair, that's right. I think the issue, when I read it, was this is sort of the wolf in sheep's clothing. You think it's a savings, but it's not, because you have to then go through the other risk assessment, go through the California requirements, and everything that California had an extra you have to solve. So it's like you did the California risk requirement in the first place.
Well, you don't have to gather the information again, which, at least in my experience, is a large part of the cost, but.
You know what I'd love to do is to have you later come back and tell us if Colorado and Europe qualifies, and if not, why. And then what we can do in this document is say, currently, these other jurisdictions, until they change, we've always amended, these other jurisdictions would qualify as a submission.
Okay, so certainly appreciate that concern. There's a bit of an issue, though, in terms of like breadth of actually what we'd be doing in terms of staff sort of evaluating the current sort of risk assessment requirements across, you know, quite a few jurisdictions at this point to do that sort of crosswalk for industry.
I'm just saying two.
Okay, so we could do that. The only concern, though, is twofold. If we were to put that into the regulation itself, it would be static. And so if GDPR or Colorado next year changes their requirements, we would then have to go through a full rulemaking. We'd have to monitor, go through a full rulemaking process to then update the fact that now actually Colorado no longer meets sort of the criteria we wanted. So there's a little bit of our concern has always been what we should probably decide on as an agency is what are we concerned about being in these risk assessments. We will try to line up as much as possible, but we would encourage basically the board not to necessarily compromise purely for that if we think there's value in what we're asking for. That's
really the APA question that I was getting at. Like, you know, we have to be really careful about pointing to other things. We point to other things. OAL will only approve it for that moment in time. And it's something that's very counterintuitive. It was counterintuitive to me. You know, again, like in my own practice, like over the years, it's always like these things will qualify, or this reasonable, you know, the standard that's reasonable will qualify. And in California, that's very, very difficult to do. That said, if the question is from Mr. Worth, is that we've picked a couple of the jurisdictions and have more information about the comparable information, how comparable the information is, so that we had a sense of how many things businesses had to independently gather. Would that help? Yeah, the punchline is I'm trying to figure out, are we being a lot more onerous than two jurisdictions people point to as successful? I don't have that language. I just like to see what are we adding to our list that they think they don't need, if anything. And we can do that.
Absolutely. I think, sorry, please.
No, sorry, go ahead.
On this, I do think I think with Colorado, it would be a little more straightforward because they use a similar regulations-based model as California, even though ours do have specific clarity requirements. GDPR might be a little bit more difficult because it's more guidance-based, and so different data protection authorities within Europe, we've seen different templates, for instance, that the UK ICO uses one, CNIL has its own. And so if it's helpful, I think like lining up Colorado and ours might be a little bit more straightforward and it enables a bit more of that comparison.
Just do that.
Thank you.
Sorry.
Just if I could, look, I think that the risk assessments got a lot of commentary about the compelled speech part. So I think we may say what we're asking, we may end up, once you've taken a look at it, if that's where the way the board goes, we may end the same stuff that's in the risk assessments is not going to end up surviving. That's one thing. And two, I don't actually think, I think, look, the GDPR they started this whole process. They're the big dog. I think I would urge us to do the two things Mr. Worth suggested. One, look at Colorado and figure out if it can work and what has to be given up if it's going to work. And then two, look at GDPR and pick a country. Just pick a country. Pick the one that's most similar to us, say if it's the UK or, France. That'll at least be something that is very familiar to businesses out there. And in terms of APA, okay, if you don't want to refer to the actual law, you could just put the section you just take their language and cut and paste it. Honestly, we can get there, and that can change over time. And nothing says that if suddenly, we did to Colorado, and next year they, changed dramatically to make their regulations weaker, we couldn't keep an eye on that. But I do think it's really a useful thing for us to do. We want to be user-friendly here, is to say, is there something that other places are already doing that we can solve a lot of effort with, and that'll bring down the cost of this as well.
One more thing I'll note, though, is a few of our requirements in these risk assessments are born from the statute, right? So the statutory language we're implementing requires risk assessments, for instance, to describe the sensitive personal information being processed, also assessing benefits and potential harms. So those are things that the statute says the risk assessment has to include. So if Colorado didn't include that, that would be a deviation. Our hands are tied. So I just want to give that example right now
That's exactly what I want to hear.
Yeah.
Right.
All right.
Wonderful, thank you. Nothing from Mr. Liebert beyond what we've talked about. So I think if legal division folks feel clear, then we can go ahead and move on. And I believe we've reached the end of your presentation. So are there any other issues you'd like to tee up for us?
Actually, before we proceed, I just want to make sure that we understand with the board's direction. So at least with the information on the slide as far as submissions, I did not hear concerns about what's on this slide. Okay.
I actually have a question about that. I'm sorry, I lost it in the conversation. I'm just trying to understand like how all this would work together. So this very light touch 6-item initial requirement would be one thing. The full risk assessments would still need to be done when the triggers were triggered. And then rather than submitting to the agency, they would be available if the agency requests them, those full risk assessments. Am I understanding this? Okay. Correct. Would there still be 2 years to do this light touch deal?
Yes. And to complete those risk assessments underlying the report.
That they need to have. Okay, I understand. Thank you. All right, I apologize, Ms. Sheikh. Please go ahead.
Oh, no, thank you for the question. So yes, it seems like the board is comfortable with the submission requirements being streamlined to what's on this slide. And then what I'm hearing from the board right now is in terms of the actual information in the full risk assessment, so what actually must be in it, you're asking us to look to Colorado and understand where we can line things up. And then with respect to GDPR, we will do our best to pick a country and see, again, where we can find harmonization. On that, I do want to provide a bit of background. We did look to these jurisdictions when it came to drafting the current language in 7152, which is the risk assessment requirements. So we have tried to harmonize as much as possible. I will also flag where you will see departures tends to be when we have to meet certain statutory or APA clarity requirements. And so when it comes to the, I understand for a lot of commenters, they're like, just use Colorado. And there's just certain language, like the context of the processing activity is one of the items in Colorado's regulations. And that's a term that we would have to clarify. And we've tried to actually do that, essentially give businesses guidance on how to get to that information with just clearer language. And so even though it doesn't appear to line up the same way, it tends to be because we have to provide additional clarity on some of this language, but we're happy to provide that information.
So thank you, members of the board, for bearing with us through this presentation. 2 things I just wanted to say. First and foremost, in addition to these items, obviously included with the materials for today was then an actual red line or strike through and underline of the text that includes additional proposals that we thought were just slightly more minor than sort of the bigger issues discussed today, but they're still here for the board's consideration, and we can discuss any of those at this point. But I do want to just reflect on what I see as actually immense progress we've made already just through these subjects. Really, if you look at it, we've sort of specified, slightly narrowed the definition of ADMT. We've cut down on the elements of significant decision. We've removed first-person behavioral advertising entirely. We are refining the training of ADMT threshold. And so, to me, this is, to a certain extent, a success today that we've narrowed as far as we have and that we've sort of progressed on these issues at a policy level, and we appreciate your feedback so far. And so with that said, we're happy to engage further on other aspects that may be still concerning to the board or up for discussion.
Thank you very much. Thank you very much, Mr. Laird. Mr. Liebert.
Well, that was a great segue because I too think we've done great work today. And thank you, Alistair, for getting the engine going today. I want to thank the staff for the 6 hours or whatever we spend on this. We have to multiply at least times 20 for the amount of time that you're all putting into it, and we really, really respect that. And of course, the public and business community and consumer groups and everybody who put in all those comments. Really substantial narrowing today that is certainly, I hope, going to reassure a lot of folks who have been expressing so much concern about how far the project was going. And I also want to reiterate that we're paying close attention to the legislature and what's happening there. And I hope staff will continue to update us about that and give us a sense of those things as issues of definitions and other things that are happening there. It should always be helpful to us in thinking about this, not just what's happening in Colorado and GDPR, but of course what's happening in our own backyard for sure. I think this is excellent work in progress as we continue to progress, and I'm really excited. I know the whole board is to now have our new ED who will be able to weigh in on a lot of this, and I'm absolutely certain that he's been incredibly impressed with the staff today and the great work that's happening here, so thank you for that.
Thank you. Mr. Worth.
Yeah, no, I can't say that. I mean, you're like the most polite legal department I've ever been in front of. No, you go. So I really, and I appreciate
that. That may be a you.
That's the depth of your understanding of all this stuff is very comforting. Well, before we leave this agenda item, I had 4 quick points, some which came from comments. One of the comments I saw, maybe more than once, was there was a lack of transparency or a lack of access to board members, which I totally disagree with. I think that I was contacted by 2 groups. One was Uber, which I brought Mr. Laird with me on that Zoom, and we had that conversation. The other was Cal Chamber, who was suing us, so I wasn't about ready to take a meeting with them. So if people want to meet with me, and I'm allowed to do that, they should just reach out. So I don't believe that comment's accurate, because we've responded to at least I responded to the only 2 outside parties that asked for access. I'd love somebody to raise their hand, not now, just to dig in deeper to that September 30th Department of Finance letter that you received, because there's just those massive numbers in there, and I want to get a better understanding of what you just, and this is not our work, this was someone else's, but you can't give me a range of minus 30 billion to positive 280 billion. Just say we don't know, if that's the answer. But I'd like to understand it better, because that has a lot to do with our competitiveness as a state. I couldn't find it. Somewhere I thought I read that our regulations are regulating business-to-business activity versus business-to-consumer. And if that's the case, I have a question as to why. I thought the purpose of this statute was to regulate activity with the consumer, not from business to business. So that's a question you can answer now or later. And then I think we're going to get back, it was Jeff Bond that wrote the op-ed piece, the gentleman has the inspection business. By the way, I went on his website. It's a very good website. He was talking about the cost of these audits. I think when we get these numbers back, we really need to dive into an example of a small business, what their individual cost is, not this $217 million number, but the individual business. I have to have some sense of it.
Maybe to that point last, I should really emphasize, and we I'll be happy to kind of work through further how we could sort of better brief you all on that economic assessment and sort of what went into it. But there is limited data available, and part of publishing the assessment is we put it out there in terms of what data sets our economists relied on when performing this review. And I make that point because cybersecurity audits are a great example of there's only so much we can do, and to the extent of, I believe we included interviews with certain audit firms and things like that to inform our assessment. But in terms of the actual cost, there just isn't necessarily robust research in this area already that our economists could rely on. So it was a bit of the agency had to basically look at what was available and reach those determinations based on that information. And so I say that because we were hoping if people had better data sets that we should be relying on or looking to, we would get that in public comment.
Can we have, well, I think it's hard for our public right, to have a lot of experience with something that they're not doing now, but can we have the consultant do some surveying in Colorado and come back with some examples?
So for the cybersecurity audits, that's actually not currently a requirement.
This is the risk assessments I'm talking about.
Oh, for the risk assessments.
Or put differently, I'm just not comfortable passing something if I don't know what the cost is going to be on the businesses in California. So somehow we got to get some information, and I don't know how to do it. But I'm certain a consultant can figure out how to get to Colorado and interview a 10-person firm, a 100-person firm, and a 1,000-person firm and find out what they're paying. I would think. Go ahead.
With regard to the B2B, the business to business, I just want to note that that's what's included in the statute. Initially, there was a provision that kind of broke out and restricted that, restricted or limited business to business activity, but those provisions sunsetted and the legislator did not extend them. And so that is why the statute now regulates business to business interactions as it relates to personal information.
And can I just, because this is something I thought about as well when I was going through the draft regulations again for this time, like in 7153, which is when processing personal information to train, actually, where are we on training? I've left that all to you all to record for posterity. But just to give an example, provide all the facts necessary. So if you make automated decision-making technology, artificial intelligence available to another business, a recipient business, you have to make all the facts necessary to the recipient business for that recipient business to conduct its own risk assessment. Like that seems reasonable and also possibly a little challenging to administer. Is this the concern, or is there a concern sort of beyond that? I mean, if we didn't have this, then we would have like a massive loophole, but I'm just trying to drill down on what the concern is.
Chair Urban, on this one, I think it might be helpful for us to actually revisit the public comments on the specific provision, just because I don't want to misstate what commenters are saying about
Fair
things.
enough. Fair enough. Thank you very much. Yeah. Okay.
And apologies not to popcorn us on issues, but sort of back to the economic assessment, my staff did remind me, Colorado actually reached the same determination. They were unable to assess the cost of their risk assessments when their provisions came out. We certainly could sort of attempt what you've described in terms of having our consultants try to interview some representative samples. And I want to assure you, an element of that did occur. So I do want to revisit that with our consultants, and we'll try to get you just additional information.
Thank you.
Thank you. I'd like to underscore what Mr. Worth said about the responsiveness of the board. And there's another example that I wanted to clarify. I think it could be just genuinely something that is not understood. And that is that for the hearings, the board or all the board were not present. And that is not because the board is not listening, not paying attention, didn't read the transcripts of the hearings. It is because anytime enough members of the board are present, it has to be a notice meeting under Begley-Keene and so forth. And so the board was very aware the hearings were happening, and we have the transcripts and so forth, but it wasn't a matter of not listening in any way, shape, or form. I'd also like to, because it wasn't part of the issues that were teed up, I'd like to say a word about the cybersecurity audits and respond to Mr. Worth, well, Mr. McTaggart. I think that Mr. Worth, given an overall cost set of cost questions, I think, you know, in the SRIA, that is by far the bulk of the cost. And I've explored this a little bit in terms of like, is it the individual, like, is it the requirements? Are the requirements too baroque? Could we bring the cost down with the requirements? And as far as I can tell, and I think this is something where there is some economic information, although I could be wrong, it is the fact of the audit. It is the fact of the audit, and maybe partly that it's an annual audit. And I will say, I wouldn't have put annual in the statute myself, because I think that is really onerous, but that's what the statute says. And so that's something I also wanted to be sure that commenters were aware that I've really looked at this quite closely. And it's something that, that at least I've paid attention to. I'm sure we could always have more information about it. But the statute requires audits and cybersecurity audits annually. The fact of the audit, the fact that it's annually, that is the bulk of the cost of all these regulations. Thank you. Mr. Liebert.
I think that's such an excellent point, and would really raise the question, obviously, whether that's something we should consider working with the legislature on. It seems to me that one of our requirements, of course, is that legislation be consistent with the statute. But that very well may be, and it could have a very beneficial effect, Mr. Wirth, in terms of the cost dynamics. If we have perhaps a consideration that maybe that annual approach is a bit rigorous. Anyway, something to think about, and maybe staff could give us some thoughts about that. That's certainly something we could consider as a board to try to accomplish.
Thank you, Mr. Liebert. So we have sorry, Mr. McTaggart, please go ahead.
Yeah, just on that last comment, and there are lots of things that I wish I had done differently, but nothing.
That was not a criticism.
No, but if you think about the costs, and you're right that the largest cost is associated with cybersecurity, but nothing stops us when you look at the language in the statute. It specifically says, it focuses on the size and complexity of the business and the nature and scope of the processing activities. And nothing says you couldn't have a very different regime for small businesses and for large businesses, And so I look at this, I think there's a ton of low-hanging fruit. If you look at this and that gets back to my motion, which is still out there, but when you look at a $3.5 billion year one cost, I think there is a ton that we can do that brings that cost down to by an order of magnitude potentially, and doesn't hurt privacy. That's what I'm really focused on right now. Because yes, you're right, having a small firm have to do an annual audit may not make a lot of sense. It'd be expensive, and it might not help privacy. Yeah.
Thank you. So that I understand the process here, we'll circle back to Mr. McTaggart's comment from the beginning of the discussion. I would think that we would need a motion. Well, maybe we don't, but let me know. I would assume we would need a motion to prepare draft modifications that, in light of the conversation today, that reflects the decisions made by the board today. And in this case, that would also include sort of more information on some things, and that they'll be brought back to the review for the board before we enter into a 15-day period, something along those lines. Would that be necessary? I just want to be sure I have these in place before, maybe not necessary?
The motion's a little bit discretionary in the sense of staff's here, we're going to do it.
Okay, yeah. I just want to be sure I have a sense of everything before we go to the public and ask for public comment, and the public has a sense of what to say of that. And then in terms of, Mr. McTaggart's request at the top of the meeting, again, I think staff's going to do that no matter what. So, but I'll turn the floor over to him.
Yeah, I think I have a motion on the table. I'm happy to reread it and amend it slightly in light of what's happened here. So potentially that would be useful. Should I do that? Because I don't know if I have a second, but I do have a motion on the table, so.
Yeah, I think my amendment goes away now because we just did what my amendment was doing, which was let's have this conversation, modify the language. I have a question. Sorry to not second the motion yet. I'm going to, but I had a question on the 15 days. You said in life, that's really a short period of time. So, I know we have some flexibility, I believe. Could we go 30 and not put you under the, in a difficult position with timing?
I think that's a really fair point, and I would be in favor generally of providing that flexibility, but maybe would probably be in favor of us discussing that when we come back, rather than predetermining what the length of review time would be, since we're not going to review them yet.
Oh, so we're going to get the language first?
Yes.
It's going to go out? I'm sorry.
We're not going to do anything more with the formal rulemaking today. I think everybody was in agreement.
And onto the motion now. I agree. We've had updates through this process. I don't know how long I've been here, but I've gotten a lot of them. But it's now like go time. Like we are getting ready to put these things out. This is the one chance we have to really analyze our risk, right? Because all the work you've done, we want to get these things in place as soon as possible. So let's just, regardless of what we've done in the past, let's do whatever you feel you need to do to analyze this stuff now once we've signed off on the revisions before we go public with them. But I'll second the motion.
Could I restate it a little bit in light of what's happened here? Amend?
I have to take away my second.
Oh, okay. Well, then don't.
No, that's fine. Please do.
I think it would be a good idea,
Yeah,
actually. I think it would be a good idea. I would like to hear the restated version.
So I said resolved that in light of the extensive comments received from the public, that the new executive director and staff produce a report for the board based on the report for the board on the cybersecurity risk assessment and ADMT regulations, including the revisions discussed by the board today. With respect to the potential for legal challenges raised in the comments, just specifically around First Amendment issues like compelled speech, other constitutional challenges, and that the regulations exceed statutory authority. The report should address, at a minimum, the list of 6 possible legal challenges I referenced earlier, which I can reread into the record if necessary. The report should make recommendations to ensure that any regulations can withstand legal challenges. And that would obviously be in the best, guess or the best opinion of the staff. The report should also examine the potential cost savings available in both the risk assessment and cybersecurity regulations if we accept other jurisdictional standards or technological standards like NIST, et cetera. Is there a way to achieve our cybersecurity functionality at a vastly lower cost? In the interim, agency efforts to promulgate and enforce regulations around cybersecurity, risk assessments, and ADMT should be paused. The director and staff should be given appropriate time to do the analysis to ensure that any proposed regulations can withstand legal challenges. And then I said, the new executive, that's my motion, and I pointed out the new executive director has been in the job for 2 days, so, yes.
Thank you, Mr. McTaggart. Mr. Liebert.
Completely understand your desire for this information. What I'm concerned about is the creation of a public document that can be misused for purposes of litigation in the future. And I would love to get the information, but I think it's the kind of information that our staff can actually prepare for us if it's pursuant to potential litigation, potentially in closed session to get that information. I don't really want to give a blueprint to those folks who might do whatever they can to try to impede the work that we're all so committed to doing. So I'm totally getting where you're coming from, but I'm concerned about this potential mechanism as a way to do it, because I think there might be other ways to get exactly the information that you want without doing it in that sort of function.
Thank you, Mr. Liebert. I just want to underscore that and say that I would be slightly firmer in my statement of that, which is I could not agree to this unless we were receiving the legal advice as privileged legal advice. I would not be fulfilling my duty to this agency or to this board if I voted in favor of extremely sensitive legal advice being discussed in the public of the board. And that's not in any way an attempt to reduce transparency for the public. That's simply basic, absolutely basic sort of laws and duties that preserve an organization's ability to get the advice it needs. So there's no way that I could vote in favor of it in that public forum.
And so, Mr. Liebert, if we received the advice in a private forum, but the public request was to come back with regulations that they felt would withstand legal challenge, so you maybe get there kind of 2 ways, that they produce revised regulations that they feel will address these challenges, and at the same time advise us in closed session as to why they're proposing the changes, that gets us to the same point. No?
Yeah, I agree with the chair that in terms of legal advice, that's something we have to always get in closed session as a privileged communication from our counsel. People who want to make arguments about whether or not we're exceeding our lane and those types of things can always be done in public, and that includes you as a board member. But the information in terms of potential what's going to pass potential litigation or not, that's a privileged communication that that we would want to get in closed session.
But if they came back, because I can rework the language here, but if we gave them the time to understand all these challenges that have been raised, or these criticisms that have been raised, that to me have a lot of weight, and they came back and advised us sort of twofold. One, in private, here's sort of the issues, and two, here's how we're going to address them with revisions to the regulations. And so the public would just see revised regulations, because I'm not sure, in fact,
that's the process we're going through now.
Yeah, but I'm 100% sure that I mean, at least in my mind, that the revisions that we've discussed today do not encompass all of the objections that have been raised by the critics, and specifically those 6 items that I read out. Like, we didn't spend any time on today, does the requirement to perform cybersecurity audits exceed what's in the statute? Like, how prescriptive we've been, which is talked about.
With respect, that's our job as the board, is to take in confidential privileged legal advice as well as public comment, and then to have a public discussion about the public components of that, keeping in mind what we know about the legal parameters, because we have had privileged information from our dedicated legal counsel, and to not expose the agency in a way that I'm not even sure would be legal, but I don't really know, by talking about that privileged information in this setting. I realize, bag leaking is very limiting in that way. It is limiting for very important reasons to expand transparency up to the absolute point that it possibly can be expanded, but it stops with legally privileged information, and it stops for a really important reason, because that is something that organizations need to be able to do in order to make good decisions. We as individual board members have the responsibility to take that information in and be able to analyze it and discuss the appropriate things in public and not the other things in public.
I'm super happy to receive it in private, but I think the exercise needs to be done. We're on notice. We are about to, if we don't address all these issues that I raised, that were kind of a compilation of many critics that all kind of said in various ways much of the same thing, and I think you want to talk about fiduciarily irresponsible, because we're going to be wasting taxpayer money on something that is going to end badly. So what I would like to do is ask the staff to take into account that area of 6 major challenges. I kind of summarized them all, and I'm happy to do it again. And then they can come back, and in public we can just have a revised set of regulations, and in private we can have a risk assessment. But I don't think that what we have done today has addressed everything that was in the criticism.
Yeah, and I don't think we intended to today, right? Because we don't have staff's response to that question. I think what I felt like we did today is we made the regulations more user-friendly and probably easier to understand. But now we got to make sure they stand up. So that's the next step. So when we get information from you, we're going to make changes to those for that purpose.
And that's, I understand that. I guess, though, there is a policy decision lurking in there, and that is ultimately also, is the board most interested in just pursuing the options that present the least amount of litigation risk, no matter what the policy result is?
No. I certainly agree with Mr. McTaggart that, to the extent we've changed these and new legal advice is warranted, we would appreciate and we need, that legal advice, but then we need to make a policy decision about our appetite for risk. And I think, the discussion I'm just going to be really frank, the discussion that we're having here right now is inviting litigation. It's basically come and sue us, regardless of whether you have a claim that is worth anything at all. Any litigation risk is not the standard that I'm worried about or that I'm going for that reason, and also because, some of this is simply, it was a very innovative law, and it has some innovative requirements, and that inherently is something that we're not going to find knowable probably in the end. So no legal risk, but I think if we have a sense of the ranges through, again, privileged information, then board members can make informed decisions about that.
You know, all I'll say is I've been consistent for a year and a half saying this is going to happen, so I don't at all feel like it's inconsistent now to say, guys, we've got to, with a relatively small amount of resources, we cannot be wasting taxpayer money. We spent a year and a half on these 3 areas. There's no discussion of do not sell, no discussion of do not buy. Everything in the rest of the bill, it feels like the entire agency is focused on these 3 areas: risk assessment, cyber, and ADMT. And so for me, yeah, I don't want to get sued on this. I have low appetite for risk getting sued on this. This is not the be-all and end-all of privacy. The vast majority of the bill is about other things. These are areas that are important, but I feel like we've spent way too much time and effort and money on this so far. We should get something that's adequate, that's strong, but let's focus on enforcing the rest of the bill. And so I would like to see revised regulations that, sure, we don't want to give away the farm. But we want to just get what the bill says: reasonable risk assessments and some reasonable ADMT regulations, and then just move on with enforcing the rest of the bill.
I think we just, we can't avoid, we can't do everything we can to avoid frivolous lawsuits, basically. I think if I'm going to restate my position more simply. Obviously, meritorious lawsuits, but the frivolous, a lawsuit is a lawsuit, even if it's frivolous. In any case, Mr. McTaggart, I believe it sounded as though you were saying that you didn't have a strong opinion as to whether we received the privileged and confidential information in privileged and confidential form or not, but I want to be sure that I'm not just making an assumption.
Yeah, I'd be happy to amend the motion to say that the report we get from the new executive director and the staff should be, I didn't actually say should be public or not public. Maybe I did afterwards in a comment, but I'm happy to have that received in closed session. But I think we would get the report, and I would expect us to be given options about, okay, here's how we're going to amend the regulations, and it's fine. We can, I guess, have that discussion in closed session if you prefer. Okay, here's the, strong, medium, weak kind of version of things in terms of the lawsuit potential. But I think we have been put on notice that this is a threat to these regulations. We should address them. It's inappropriate for us not to.
Thank you, Mr. McTaggart. Mr. Wirth, did you have something to say? And then I think Mr. Laird may want to clarify.
I want him to clarify before I second.
Yeah, there's a few things I heard that I think we do need to clarify. So first of all, unless we're in litigation or have real threat of litigation, we can't actually discuss this in closed session. I can provide you one-way legal advice, the confidential legal advice, but I don't want to put anybody under the assumption that we can go into closed session to debate these issues further. So having said that, though, we would be prepared and happy to provide legal advice to this board like we have in the past on these relevant issues. The other point I was going to make is I agree. I don't want to take more time than we need to on this. I think we've moved the ball significantly forward today. And so when I hear concerns about there's still issues, I see 2 hours left on the clock. I need to hear them, frankly, if I'm going to understand what needs to be resolved still. It's hard for me to predict at times what the concerns are if I don't have specificity.
Yeah, I think, though, you're not going to, what we're asking for now is work product that we don't have, right? It's, let's take the revised regulations, let's sign off on them once we see the draft, and then have you do that legal analysis for us. So that's not going to occur today, unfortunately.
Sure, yeah.
Mr. Liebert.
Thank you for that clarification. I think that should work fine for my judgment. It doesn't need to be a closed session. You're right. Our lawyers have always given us good insights about these types of issues, and that's exactly the information that we're after. So thank you for that.
Thank you, Mr. Liebert. Okay. Yes, sorry, Mr. Wirth and...
Are you changing your motion?
Well, I'm happy to, but before I was going to change, I was just going to point out to Mr. Laird, some of the things I don't think we have the answer today. I'm not looking for the answer today, but just some of the, there was a lot that they brought up that in terms of the public comments, but just, we didn't spend any time really on the cybersecurity audit, how that interplays with the prescriptiveness. We didn't spend any time on the risk assessments, the compelled speech. If you go through what's in the risk assessment, what the people are supposed to assess, and how much of it has to do with actual risk versus, like, you get into the whole world of discrimination, and so that, and I've raised that before. We dealt with, I think, behavioral advertising today, and I think we're going to be dealing with the first-party advertising. The pre-use notice, is that compelled speech? All these kinds of things that, are the ADMT regs an unconstitutional delegation of power? These are things that have been brought up, and I think we really need to kind of go through, and I'm amazed that you guys had the time to go through all those, 1,600 pages of comments, but go through them all, and I'm happy to get a one-way communication from you, along with, here's how we're going to solve it, and then I guess the public would just see the revised regs. But and maybe there's another version of this where you come up with a couple of options and we vote on those. But I think I want to pause and make sure we get it right, because I feel like what's frustrating to me is seeing this sort of small group of stuff over here take up this much sort of, intellectual, emotional, and financial energy. And I'd like to get it behind us. And we're not going to get it behind us if we push the envelope and we're sued for 4 years. And I think when I think about the scope of privacy, this is not where the rubber meets the road. This is important, but the real important stuff is I want to make sure that I have control over my information and know where it's going. And I want to be able to go to a website in California and find the do not sell and do not share button. I mean, look at that. We had one of those groups, the Privacy for Cars people, they sent in, they made, 128 requests to one car manufacturer, couldn't even get a request in because the stupid portals never open. I mean, that's the kind of thing where you're like, hey guys, we've got a real fundamental problem with privacy here, and these companies are not honoring it. That's where I feel like we should be spending our time right now.
Thanks, Mr. McTaggart. So as I understand it, the motion on the table has the 6 components, and it's agnostic as to the confidentiality part of it. And then we don't need a motion for the revisions to the regulations because staff have that settled and sorted out, and understand the questions about the economics. So much as it's possible to find the answers to those. Do I have that right? Do we need to vote on the motion? I mean, I think
that's what I was going to say. I don't think even
my main concern is the privilege part.
I'll try to on the fly restate it one more time.
I mean, I'm not sure we need to vote if the staff understand it and they plan to.
Will you do what we just asked in the motion? Yes, we don't need the motion. Sure.
We can carry that out, absolutely, and provide the legal advice. Yeah.
Fantastic.
Yeah.
Fantastic. May I ask if there's any public comments?
This is for agenda item 3. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. I believe there are a few hands raised. First, we have Julian. Julian Kneet, I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Thank you, and good afternoon, members. Julian Kneet, President and CEO of California Hispanic Chambers of Commerce. On behalf of our membership,
Mr. Kneet, you're quite in and out. Can you get closer to the microphone, please?
Sure.
Thank you.
Julian Kneet, President and CEO of California Hispanic Chambers of Commerce. On behalf of our membership, I offer some comments on the potential modifications to the proposed CPPA regulations. In regards to definition of ADMT, our organization supports alternative 3. We believe the removal of the vague terms such as substantially and facilitate is workable. In regards to significant decision, we can support alternative 1, removing access to. Improves the clarity of the term scope. The concept of access to does not have a clear limiting principle. Striking it would create firm framing for businesses that will have to build and comply with regulations. In regards to behavioral advertising, removing behavioral advertising for risk assessments and ADMT requirements from the regs would leave the underlying protections from Prop 24 in place and be consistent with statutory text. Public profiling, we support the alternative, removing public profiling from both risk assessments and ADMT will help address our issues. This concept has no basis in the underlying law and is unnecessary to include. In regards to the issue of training threshold, we support alternative 2, removing training thresholds for risk assessments and would correctly limit the impact of CPPA regulations on the development of AI. In regards to risk assessments, the new language requiring risk assessments must be provided upon the request by the agency or the Attorney General addresses concerns we have about the security around risk assessments and creates clarity of how they will be shared. In regards to effective date, we appreciate the effective date of ADMT regulations was moved to January 1, 2027, and cybersecurity to January 1, 2028. We ask that the rest of the regulations also become effective on January 1, 2027 to provide businesses with a date certain to prepare for compliance. We believe that the changes we are asking for, if adopted, are steps in the right direction and will help minimize the impact to businesses in California. Again, I appreciate your consideration of our testimony today. Thank you.
Thank you for your comment. Swati Chintali, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Good afternoon. My name is Swati Chintala, and I'm sharing these comments on behalf of Tech Equity. California has a historic opportunity to lead in establishing critical transparency, disclosure, and validation requirements for ADMT. As noted by the Joint California Policy Working Group on AI Frontier Models, instituted by Governor Newsom, transparency and independent risk assessment are essential to align commercial incentives with public welfare. The arguments we've heard in public hearings from industry, representing some of the richest and most powerful corporations in the world, are part of a larger effort, which we also see being played out in the legislature, to block common sense frameworks to protect Californians' right to privacy as outlined in the CCPA, including how their personal information is monitored, collected, and used to make decisions about them. In the face of unprecedented and widespread attacks against federal agencies that are responsible for protecting consumers, workers, and other impacted groups, we urge the board to recognize the significance of establishing the necessary protections that Californians voted for in the CCPA. This includes defining ADMT in ways that do not exempt automated systems that only have cursory human involvement. As Chair Urban noted, a national health insurer used automated systems that used personal data to analyze insurance claims, and doctors are meant to review them before making the final decision to deny or approve payment for patient care. An investigation found those doctors spent an average of only 1.2 seconds to review each health insurance claim. Under the alternative definition of ADMT considered today, a business could point to that as a kind of token human involvement to opt out of CCPA requirements to provide proper notice and explanation, even when that business's use of their personal data creates significant risks to the consumer of an inaccurate or incorrect decision. The CPPA's mandate is to ensure that people in California have the tools necessary to advocate for their rights in our data-driven economy. The board must use this rulemaking process to balance the industry's immense power with the necessity of privacy and data protection for Californians. We agree with the CPPA's standardized regulatory impact assessment that the proposed regulations strike a good balance between the desire to strengthen consumer privacy and recognition of the importance of the information technology sector to the Californian economy. By placing guardrails in the form of these regulations, the CPPA can ensure that data-driven technologies are not developed at the cost of the rights of ordinary Californians. We look forward to the passage and implementation of these regulations. Thank you to the CPPA director, staff, and board for your important work.
Thank you for your comment. Jose Torres, I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Good afternoon, Jose Torres on behalf of TechNet. We represent over 95% in the technology and innovation industry. We represent companies across the spectrum of the innovation economy, from companies who develop this cutting-edge technology to the many more companies who deploy it for consumers and business users who use automated decision-making technology in some capacity to improve their business operations. I would like to thank the board for your efforts today and the outline of draft amendments. We are encouraged by the direction of the draft seems to be taken. However, while the proposed modifications are a step in the right direction, the board should consider further changes to keep the regulations from extending beyond the core privacy concerns this rulemaking is meant to address. Some parts of this rulemaking still seem to be trying to address broader concerns about ADMT and risk, rather than strictly privacy, that could arise when technology is used to make important decisions. That's a topic worthy of a debate, but it goes beyond the scope of this rulemaking and only makes this rulemaking complex and costly to consumers and the state economy. The board should ensure regulation can be connected to a genuine significant threat to privacy, so that the costs and burdens of regulation are justified. With that said, I want to touch on a handful of decision points. As a threshold issue, definition of automated decision-making technology is a concern because of its continued overbroad inclusion of numerous low-risk forms of software. As has been noted by board members during previous meetings, the definition as it is currently proposed would include far more technologies than intended. From the three alternative options being considered, we would like to see alternative 3, ADMT means any technology that processes personal information and uses computation to replace human decision-making for the purpose of making a fully automated significant decision about a consumer. This alternative more appropriately focuses the regulations on high-risk use cases of ADMT that replace human decision. Accordingly, regarding the significant decision definition, we would like to see the phrase access to deleted rather than changed to selections of the consumer form. Under the same section, we would prefer that alternative number 4, which deletes the phrase allocation or assignment of work. Under behavioral advertising, urge the board to strongly consider the alternative deleting that section. Keeping that language as is would undermine and contradict the existing definition of cross-context behavioral advertising in CCPA. Under work or educational profiling.
Thank you for your comment. You are at time. Edwin Lombard, at this time, I'm going to unmute you. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Hi, my name is Edwin Lombard with ELM Strategies. Today I'm representing the California African American Chamber of Commerce and multiple local ethnic chambers throughout the state and business associations. On behalf of our members, I appreciate the opportunity to comment on the potential modifications to proposed CPPA regulations. Our businesses remain concerned about the significant financial impact of the CPPA's regulations, but we believe that some of the potential modifications, if adopted, may help address some of the concerns we have. As far as the effective date is concerned, we appreciate that the effective date of the ADMT regulation is moved to January 1st of 2027 and the cybersecurity to January 1st of 2028. We are requesting, however, that the rest of the regulation also become effective January 1 of 2027 to provide businesses with a date that is clear and will help businesses prepare for compliance. On the definition of ADMT, we support alternative 3. We believe the removal of the unclear terms such as instability and facilitate will be helpful for compliance. On the definition of significant decision, we support alternative 1, removing access to improve the clarity of the regulation. The concept of access to is too broad. Deleting it would create clear expectation for businesses that will have to develop the compliance and regulation. On behavioral advertising, deleting behavioral advertising for risk assessment and ADMT requirements for the regulations will be consistent with the fundamental protections under Proposition 24 and consistent with the statutory language. On the issue of public profiling, We support the alternative of deleting the public profiling from both risk assessment and ADMT, as it will help address our issues. We believe the concept of is completely unnecessary and has no basis for existing law. On the issue of training threshold, we support alternative 2, removing training thresholds for risk assessment, and would correctly limit the impact of CPPA regulations on the development of artificial intelligence. On the issue of risk assessment, a new language requiring risk assessment must be provided upon request by the agency, and Attorney General's address our concern about the security around risk assessment and create a simplicity of how it will be shared. Thank you, and we look forward to continue to work with CPPA so that California's privacy regulations are reasonable and balanced and required under Prop 24.
Thank you for your comment. Ben Golombek, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Thank you, Chair Urban and members. Ben Golombek on behalf of the California Chamber of Commerce. The business community has repeatedly raised several concerns about the draft released in November, including concerns that it lacks calibration to privacy and security risks, departs from established global frameworks, significantly underestimates costs, and dramatically overreaches the agency's authority. And there are real consequences to these concerns, specifically when you look at cost. And the Sharia's, in our opinion, very conservative estimate, which we think underestimates the true cost of the economy, is $3.5 billion in a year. With Californians struggling to pay their bills, this is not the time for a massive tax increase. Looking at the draft that was presented at the beginning today, we were disappointed that it did not address these concerns. We also recognize that among the alternatives presented today are a few options that can help, and we just want to encourage you to continue to engage on those and some of the other points. Specifically, absent significant amendments, the ADMT requirements overreach the agency's statutory authority and veer into general AI regulations, and as was pointed out, and it's important to avoid getting ahead of the legislature and governor. We encourage the agency to focus on the narrow issue within the statute's direction, clarifying how the CCPA access and opt-out right should be interpreted in the context of ADMT. On the ADMT definition specifically, our comment letter again reiterates and proposes language most similar to Alternative 3 in your slides. The current draft frustrates a number of privacy and security objectives that undermine harmonization across legal frameworks or otherwise conflict with the privacy interests that voters endorsed in Prop 24. For example, the threshold activities that require risk assessments and ADMT opt-outs far exceed those required by other U.S. privacy statutes. Finally, on a process point, the board advanced these regulations on the understanding that the formal rulemaking process provided the, quote, procedural opening to engage in the, quote, structural, legal, and practical revisions needed. We appreciate the conversation today and encourage you to implement other changes that better recognize the concerns raised by the business community since 2023. We're asking for a 45-day comment period consistent with OAL's instructions and a second 45-day comment period to inform changes given the highly technical nature of the requirements and the potential to devastate our innovation economy. We do want to acknowledge that the conversation today, particularly around behavioral advertising, was a step in the right direction. I would say it's probably the first step in the right direction since this process began, and we'd strongly encourage the agency to continue down that path. Thank you, and have a good day.
Thank you for your comment. Alex Torres, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Good afternoon, everyone. Alex Torres with Brownstein Hyatt on behalf of the Bay Area Council, representing over 340 of the largest employers in the 9-county Bay Area. I want to say thank you for the opportunity to provide comments on these regulations. And for the proposed to align my comments with our friends at TechNet, California Hispanic Chamber, and Cal Chamber on the need to keep working with stakeholders on those alternatives. I would also reiterate a point CalChamber made about the draft AIT regulations going significantly beyond what Proposition 24 envisioned. And again, would also encourage this body to continue working with the legislature and the governor's office and get better aligned on the comprehensive frameworks to govern AI and emerging technologies that those folks are working on. These efforts include privacy experts, civil rights experts, industry leaders, and technologists. Stepping back at a higher level on the proposed rules would impose over $14 billion in compliance across the next 10 years. With affordability being such a major concern from California in virtually every aspect from energy, housing, and essential services, this is not the time for this course of action that would have such significant economic impact. So again, would encourage the CBPA to support the leadership already underway in the legislature and the governor's office, and would just underscore we support smart, reasonable regulation that protects consumers, supports innovation, and sustains that economic resilience. Thank you for the opportunity today.
Thank you for your comment. Odin Downey, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Good afternoon. My name is Aiden Downey, representing the Computer and Communications Industry Association, CCIA, and International Not-for-Profit Tech Trade Association. In January, CCIA provided written feedback and oral testimony during the 45-day public comment period on the proposed CPPA regulation updates. Along with many other organizations, CCIA expressed concerns that some of the draft provisions go beyond CPPA scope, particularly provisions that regulate companies' back-end systems before they ever interact with consumers, and those that regulate publicly available information. While we appreciate CPPA's continued efforts to refine the proposed rules, we feel that the revisions do not adequately address our prior concerns. CCIA also appreciates the board's thoughtful discussion today. We welcome the opportunity for more collaboration and look forward to submitting more comments based on the recommendations of the board. Thank you.
Thank you for your comment. Michelle Khan, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Can you hear me?
Yes, we can hear you.
Okay. Good afternoon. My name is Michelle Khan, and I'm giving public comment on behalf of Dr. Netta Bernhardt, Director of the Technology and Work Program at the University of California, Berkeley Labor Center. With the advent of big data and artificial intelligence, employers in a wide range of industries are increasingly capturing, mining, and analyzing worker data, electronically monitoring, using algorithmic management to make critical employment-related decisions. And yet, California is the first and the only place in the U.S. where workers are starting to gain basic rights over their data and over how employers use that data to make critical decisions about it. That's why labor groups and other worker advocates are paying such close attention to the CPPA rulemaking process. In January, we joined a group of worker advocates with a formal comment letter to the CPPA, providing detailed and based recommendations about how best to protect workers in the agency's rulemaking on ADMTs and risk assessments. Our recommendations are grounded in the principle that the scale and scope of data-driven technologies in place necessitate broad protections. For ADMTs, the letter identifies 3 priorities with specific suggestions. First, expand the definition of ADMT to fully reflect the significant and how and to what extent employers rely on ADMTs. Second, strengthen notice and access rights for workers when an employer has used an ADMT.
Apologies for interrupting. Is that clear on the electronic feed?
It's choppy there as well.
Okay, I just want to be sure our commenter comments are recorded. Should we pause? Thank you, commenter. Give us 1 technical second here.
Sure.
Okay.
It's not on our.
But it's been every commenter.
Yeah, it's been quite a few commenters who've been shown.
Yeah.
Maybe she could speak again very closely to the mic.
Yes.
Yeah. Commenter, would you be able to start from about 10 seconds ago and just speak very closely into your telephone or mic?
Yeah, is that better at all?
That's definitely better.
Yes,
Thank you so much.
Thank you.
Okay, moving close to the mic. Our recommendations are grounded in the principle that the scale and scope of data-driven technologies in the workplace necessitate broad protections for workers. For ADMTs, the letter identifies 3 main priorities with specific suggestions under each. Expand the definition of automated decision-making technology to fully reflect the significant variation in how and to what extent employers rely on ADMTs. Strengthen notice and access rights for workers when an employer has used an ADMT to make a decision about them. Store a meaningful right for workers and consumers to opt out of consequential ADMT systems. For risk assessments, the letter similarly identifies 3 main priorities with 6 suggestions under each. Strengthen the required elements for risk assessments to ensure the potential harms to workers are identified early on. Clarify the role of workers and unions in risk assessments because they are critical stakeholders and sources of knowledge that should be involved when their employers conduct assessments. And then finally, strengthen the power of the CPPA to act on risk assessment in order to prevent the most harmful violations revealed by those assessments. In closing, by covering workers in the CPPA and adopting strong regulations, California has a historic opportunity to lead the U.S. in ensuring that data-driven technologies benefit and do not harm workers. That is why we strongly urge the board and the agency to adhere to the intent of California's privacy law and proceed with the rulemaking process as directed by the state's voters. Thank you for the opportunity to comment.
Thank you, commenter. Apologies for breaking in again. I want to check with council for any commenters who are worried about their comments cutting out. Are they able to send an email to maybe info@cppa.ca.gov to be sure the board doesn't miss anything?
Absolutely.
Okay, wonderful. I do believe that the feed that we're hearing is more choppy than the feed that will be on the recording, but at the same time, the recording feed is also not perfect. So for any commenters who wanted, this was the first time I really felt like I was having trouble following there in the middle, to be clear, for the rest of the commenters. But if anybody wants to send that in as an email to be sure the board doesn't miss their comment, we'd appreciate that. Thank you. Please go ahead.
Thank you. Anthony, I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Good afternoon. My name is Anthony Butler Torres, representing Kern County Hispanic Chambers of Commerce. We are encouraged by the potential modifications suggested by the California Hispanic Chambers of Commerce to propose the CPPA regulations. Our small businesses utilize AI and other forms of technology to make their businesses more efficient and to minimize the cost of doing business in California. Proposing regulations that consider the potential impacts on our small businesses community should always be the forefront of developing these regulations. We cannot stifle innovation and the growth of small businesses community in California's economy. We hope that the CPPA board will take into consideration the impacts on small businesses in finalizing the regulations. We are encouraged that some of the changes that are being proposed, if the right modifications are adopted, it will be the right step in the right direction and will help minimize the impact on our small businesses community. Thank you for your time.
Thank you for your comment. Peter Leroy Munoz, I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Good afternoon. My name is Peter Leroy Munoz, and I'm speaking on behalf of the Silicon Valley Leadership, a business association representing companies and research institutions in the innovation economy. While we understand and agree that having consumer protection guardrails is important as technology evolves, we believe the proposed regulations concerning autonomous decision-making technology and artificial intelligence will impose significant burdens on California consumers, innovators, and businesses. The proposed rules around ADMT pop-ups will create significant burdens for those wishing to conduct research or transact business over the internet. In addition to separate notifications regarding consent for cookies and promotional communications, users now face further pop-ups, one for receiving information on ADMT and a second regarding the use of ADMT for delivering advertising based on prior activity. California consumers broadly should not be impeded at each step of an online transaction. This complexity around ADMT notifications and opt-outs also harms businesses who may see frustrated consumers leave their site before completing a transaction or leaving before the business could share important information with users. This risk is especially pronounced for small and local businesses who depend on online commerce to supplement their limited physical presence. Restrictions on the use of ADMT and AI could harm small businesses by limiting their ability to use digital tools to reach consumers, share offerings, and conduct transactions. Business costs will also grow amid our current inflation as small operations will need to hire additional staff to address legal and compliance issues around new rules. Finally, the standardized impact assessment prepared in conjunction with proposed regulations reveals their true cost to California's economy. Report finds a reduction in state gross product in the billions of dollars and a decrease in job by hundreds of thousands. In this time of greater economic strain and higher cost of living, especially given the detrimental federal policy posture toward trading partners, California workers, innovators, residents, and businesses cannot afford the proposed ADMT and AI rules. Thank you.
Thank you for your comment. Gilbert Lara, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
Hello, board. Can you hear me?
Yes.
Great. Good afternoon. My name is Gilbert Lara, representing Biocom California, the largest life sciences trade association representing thousands of companies across California. We appreciate the board's significant progress today in narrowing the ADMT definition, removing references to AI, and streamlining risk assessment submission requirements. These changes show responsiveness to industry. However, some concerns remain for our life sciences companies. First, the cybersecurity audit requirements could still create duplicative compliance burdens. Life science companies already conduct audits, federal and international regulation. We urge the agency to consider accepting existing frameworks to satisfy these requirements. Second, regarding ADMT use in healthcare, we are encouraged by your decision to provide further clarification of healthcare services and exemptions. Stress that as you develop these clarifications, keep in mind the critical role of medical research and public health application. We would be happy to work together on this issue. And finally, we appreciate the board's recognition that risk assessment costs impact business. As you gather more information on implementation costs, please consider the unique position of smaller companies developing life-saving treatment. Thank you.
Thank you for your comment. If there are any other members of the public who'd like to speak at this time, please go ahead and raise your hand using Zoom's raise hand feature or by pressing *6 if you're joining us by phone. Again, this is for agenda item 3. Fred Sotelo, I'm going to unmute you at this time. You'll have 3 minutes to make your comment. Please begin as soon as you're ready.
My name is Fred Sotelo, and I'm the owner of Cerveza Azteca, based in San Diego, California. We're a craft beer company. And as a small business owner in California, I'm pleased to see the recommended modifications of the CPPA regulations. You know, I'm happy to see that these potential modifications will minimize the impact on business owners like me. Who would think AI would be an integrated part of a beer company? Well, it is with Azteca. Under our current economic market conditions, we utilize AI to assist to be more efficient in all aspects of our business, from vehicle tracking and mileage, inventory, sales forecast, and of course, marketing. We believe AI is critical for our success, and the myth of it cutting out people is not true. On the contrary, it is helping our bottom line to hire more needed people. In closing, we believe that the changes being asked for, if adopted, are steps in the right direction that will help California continue to be an innovative leader and for small business like us to continually compete. I thank you for your time and consideration today in this testimony. And once again, thank you.
Thank you for your comment. If there are any other members of the public who'd like to speak at this time, please raise your hand using Zoom's raise hand feature or by pressing *6 if you're joining us by phone. Again, this is for agenda item 3. Madam Chair, I'm not seeing any additional hands at this time.
Wonderful. Thank you very much. Mr. Laird, is there anything else on the item?
No, not at this time. Just one, though, thing that's on my mind is timing about sort of our remaining time with these regulations. As I mentioned, November is our goal to have a final package submitted to the Office of Administrative Law by, if not sooner. And I understand our next planned meeting for this board is currently May 2nd. That's a quick turnaround for us, and so staff would make every effort to prepare materials we discussed today, but there's a lot. And so a couple thoughts or issues I wanted to run by the board include, first of all, to the extent we can prepare things in advance, just recognizing because of the less than a month timeline between today's meeting and that meeting, we may not be able to give the board the benefit of the materials for as far in advance as we'd like to typically. So I just want to see if that's acceptable, first of all, if materials are coming to the board closer to that meeting. But in addition, right now, I believe the only other planned quarterly meeting isn't now occurring until September based on the discussion of last meeting, which really puts us in a difficult spot if we were to delay modifications or hoping to do more further. So I bring that up now to just make 2 points. One is we'll make every effort to bring this item back at the next meeting, but it is a quick turnaround for staff, and I just need to make clear now there's a chance we wouldn't be able to be prepared in the ways that you've asked us to be by that date. And then even furthermore, I would request, I think, given the timelines associated with this rulemaking and wanting to open a public comment period for potentially more than 15 days, respond to that public comment, process it, and come back to you all for another discussion just like this today, still in advance of November. I think we need to have at least one more meeting in advance of September.
Thank you. And our held days, we have a held day in July, is that correct? But we don't have one in June?
Well, we did, but last meeting, the board did decide to.
Apologies.
Yeah, we released them.
Release it.
Okay. Yes, the Thursday, however, I think that would be even earlier than May 2nd. I mean, one day, but even earlier. So I will say for myself, particularly if you give us a little notice as to when the materials are coming, I would certainly do, my utmost to absorb the materials in less time. I think that's only fair given the amount of homework that we've asked everybody to do. I mean, we do have some questions that are fairly targeted. And we've already had time to go through the comments that we have and so forth. So for my part, that makes sense. And then, maybe we need to talk about, we just need to talk about when we might have another meeting outside of May 1st or May 2nd. I do apologize, though. I really need a break. So if we could, I don't think I can think about dates until I have 5 minutes.
And I do recognize if setting dates is better at the future agenda item coming up, we can discuss it then. So
okay.
Substantively, though,
that's all right. That's all right with everyone else. Why don't we table it till the next agenda item? But we know that that's something that we're going to talk about, and then we'll take a break until 3:30. Thank you very much. Welcome back, everyone. Thank you for your attention to the agenda so far today. With that, we'll move to agenda item number 4, which is our item for public comment on items not on the agenda. So as a reminder, this is the opportunity today for members of the public to bring to us issues that are not on the agenda for today. However, the board can only listen, and we may not discuss or act on any matter that is raised during this public comment session. So please understand that we are listening, and we don't intend to ignore your comment, but this is the only way that we can adequately attend to the interests of both the commenter and to the agency. So with that, is there any public comment on agenda item number 4?
This is for agenda item number 4, public comment on items not on the agenda. If you'd like to make a comment at this time, please raise your hand using the raise hand feature on Zoom or by pressing *9 if you're joining us by phone. This is for agenda item number 4, public comment on items not on the agenda. Madam Chair, I'm not seeing any hands at this time.
Thank you very much. We'll move to agenda item number 5, which is a discussion of potential future agenda items. I'm pleased to handle this item, and we'll say that we do have a number of things on our regularized calendar, some of which we have pushed off until a later meeting. Currently in the meeting that is scheduled for May, so I will just mention those issues and then ask Mr. Laird to help us continue the conversation that we started earlier about the best time frame for scheduling further consideration of the draft regulatory package.
Oh, sorry, should we do that now as opposed to, did you want to run through the other items or?
I wasn't planning to do the whole list this time. I did it last time.
Okay, got it. Yeah, in terms of timeline, I guess I just reiterate what I said before, that we will make our best effort to bring sort of the issues and items discussed today back to this board, assuming it's going to meet still on May 2nd or May 1st on that held 2-day meeting. But then beyond that, we do anticipate, again, to continue to make sure things keep moving, and then we can kind of timely respond to any public comment that might come following that meeting. We would ask to explore a mid-July meeting if possible. But with the caveat that we'd also have to be able to check for facilities.
Excellent. Yeah, understood. So if we're able to give you sort of a range or some like multiple dates, that will help. Yeah. Okay, great. Thank you. I'll say from my part, it's helpful. I'll be outside of term time, which provides more flexibility. Of course, I know people have family obligations over the summer. So Mr. Wirth, where you have your microphone on, you start us off?
Yeah, I think I wanted to start with May. My understanding is that one board member can't make the Friday.
That's my understanding, yeah.
But can make the Thursday, and I think we decided we only need one day since we're just, what we're doing now. Is everybody okay just to confirm that date?
Yep.
Then we can get into the next?
Yep.
That's the Thursday in May.
Yeah.
I believe it's May 2.
May 1st.
Oh, sorry, May 1. That's right.
And that'll be in Sacramento.
We're in Sacramento again?
Mm-hmm.
Okay. Oh, yeah, that's right. I'm sorry. Do you want, are you looking for July dates now?
Well, real quick, I was just going to mention too, right now, to the point that was made earlier, I think for the May meeting, we do have 3 standing items on our calendar, updates on legislation, enforcement, and public affairs. And we also did push off last time an update from admin as well, and then our regulations discussion, which I think this can be a regulations discussion for now. So I would recommend we continue to push off maybe that one for a future discussion. But understanding we'd be trying to tackle this subject matter and potentially 4 other pretty substantive updates in that time, I guess I would just want to ask the board now if there's anything, just for staff's ability to prepare, that you'd be comfortable pushing off to the further, any of those updates. I think legislation, we're on a timeline in terms of the legislature's active now. I think we'd have to maintain that, but certainly if it would be all right, and staff could come back with a recommendation, but I'd want to understand now if there's anything that the board was focused on maintaining in the May meeting.
Yeah, so for me, I think it's the legislation item is the main item because of the legislature's calendar. We certainly want to be responsive to what they're doing on a timeline that makes sense. The discussion of future priorities for rulemaking, to me, that would be fine to push off to a later meeting because we have before us plenty on our plate right now. And I would ask if other board members had views on this.
I mean, I think just put it all on and you'll give us direction on what we don't get to that day in case we're lucky. I decide today what to drop. It's easier for me to say because you'll say, well, because we have to prepare now for every item. So if that's the case, you give us direction on what you feel most comfortable pushing.
I'm going to defer to my leadership on that.
Excuse me. Well, thank you for staff and preparing, yes, but I would say admin, we've already prepared the material, so we can put it on the agenda again, but we feel comfortable pushing that, for example, as well as enforcement. But we're happy to prepare.
The proposed regulation, the priorities for regulation, that seems to me to be something that takes significant time to prepare. And at least for my own part, I feel less likely to be in a position to engage on that at that moment. But other board members may have a different view. Mr. McTaggart?
So before I weigh in on what I think for timing, let me just ask you a question. If the revisions come back and we go through this process and they're pretty substantial, at what point do we need to do a new SRIA and take a look if we have some pretty massive cost swings here, potential cost swings, at what point do we need to do a new SRIA?
So great question. We're not required to do a full SRIA, standardized regulatory impact analysis. We would do an update of what all rulemaking packages have to do. It's the Form 399, which is the economic impact assessment. In short, it's a 5-page summary document that reaches conclusions about costs in first year, things of that nature. So it's not sort of the robust requirements of a SRIA, but it still would be providing additional information based on the regulations that we agree to. Yeah.
And we can go ahead and discuss we can receive information and discuss the questions that, for example, Mr. Worth brought up. We don't need to do a SRIA in order to talk about that, even though it's fairly meaty. Is that correct?
That's correct.
Yeah.
So literally, even let's just say you said we're going to replace the cybersecurity requirements, and we're going to say if you meet in one of these 10 jurisdictions, you're good to go. So let's say it's a dramatic reduction, and we kind of carve way back what is required to be done. We just, you need to provide evidence it's done. And let's say it went from whatever it was, $2 billion down to $200 million. You would not need a new SRIA.
No.
Wow.
Mr. Liebert.
Which is a conundrum, right? Because one of the things that we'd like to be able to, not only we want to have accurate information in that regard, but we also want to have a sense that we've dramatically reduced cost. And so is there an alternative for getting that information out without doing an additional SRIA?
Well, that absolutely is included in that Form 399 I mentioned. I mean, that includes estimates on number of businesses impacted, estimated costs in the first year, estimated costs associated with reporting requirements. I mean, there is a lot of substance to that. It just doesn't have the same sort of additional macroeconomic assessments and that additional.
So actually, staff would theoretically be able to point out that starting from that big number, it's fair to bring it down to this number based upon the changes that have been made.
Yeah, absolutely. I think certainly costs in the first year, things of that nature, we would assess and bring back to the board that this is how that has changed as a result of the proposed revisions.
And to Mr. Lieber's point, you guys do that, or you guys do that, or the outside firm does that?
To date, we've worked with economists. Yeah, we're in contracts with economists from UC Berkeley, Sacramento State, and we also have a retired annuitant on board who's been supporting our work.
Yeah, because without being absurd, I feel like we want to get this right, and so I'm very conscious of the fact that it's May is less than a month away. We can't ask people to do work around the clock on this stuff. So I feel like within reason, what gets done by then gets done. But because I don't feel like this is a critical path for the success or failure of the bill, I think we just need to spend the time to do it right. And getting back to something I said earlier, this is the new executive director's third day on the job, so he's going to need some time to get up to speed on things as well. So I'm kind of agnostic about what gets discussed in May and what gets discussed later. And then can you just remind me, Mr. Laird, what happens if we trip over November? So what's the process then?
Very good question. So after November, we would essentially start from the beginning. And when I say that, I mean we would do a new notice, a new initial statement of reasons, a new SRIA in that instance. If you were starting with the exact same proposal, I would say in general, you're rulemaking record actually look very similar to what we started with this time. But where you would start after November is a significantly modified version of the regulations. For instance, we would then have to prepare the supporting documentation that reflects that new version of the text. So a new SRIA, a new initial statement of reasons on that basis. And then we'd start over, you all would decide if that was sufficient. We'd have a 45-day public comment period. We'd respond to all those public comments. We would then prepare a final package.
Mr. Liebert?
Sorry, we're keeping you so busy here, Phil. How does this impact the staff's incredible work on the DELETE Act implementation? Is it intruding on that? Is it, I'd love to get some sort of sense on that because that's such an important priority.
I appreciate that. To date, we've been able to balance those two priorities pretty well, but certainly we have a limited team where you've got a good majority of them up here, either at the dais or in this room today. And so, our capacity is limited. So at a certain extent, the more time we're spending on this rulemaking is more time we're not spending on other initiatives in the agency.
I'd like to just make an observation, which is that we have expended significant resources on this rulemaking. And I absolutely agree with Mr. McTaggart that we need to get it right. We need to get it right in the realm of reality, and we need not to waste the public's resources on endless process. And I would be very concerned if we had to start over and do, for example, a new SRIA, which is a very valuable set of information, but because of the requirements around it, it takes months and months to do, and it costs a ton of money. That is the taxpayers' money. And I'm just not sure how much more information we're going to get after 3-4 years of information gathering, listening attentively to the public, to our partners in the legislature and other agencies. So I would really encourage the board not to be casual about kind of, extending things further beyond that, because it is a significant use of resources, and I haven't even mentioned staff time. I thank Mr. Liebert for bringing up, for example, the DROP system, which is crucially important. We have a lot of things to do here, which is not to say that these aren't crucial and important regulations. They are. They touch a broad swath of the California economy and all consumers in California. But my word, we do have to come to terms and make a decision and comply with our statute to do that, so that businesses have certainty, so that consumers have the protections, and so that we are not just endlessly spinning and burning resources on this process, remembering that a lot of this is new, and we simply will not have information about the details of every single thing until we see them implemented, and then we, of course, can implement a new process to improve them. But there's perfection, and it is not attainable, and there is good, and it is attainable.
Sure, and my rebuttal to that would be, sure, we have to be conscious of the cost of a new impact report, and we are. I'm actually. 4 years of staff time. Could I just finish? And at the same time, our own estimate is 98,000 jobs lost. $3.5 billion cost of regulations, which dwarfs the cost of a new impact report. So I just want to make very sure that as Californians and as stewards of public money here, we're keeping an eye on the bigger picture. And the bigger picture is, what's the impact of these regulations? And if our own estimates show this, we absolutely owe it to try to say, is there a way to do what we're asking for, most of what we're asking for a lot less impact on the California economy, where we don't kill 100,000 jobs?
I do not think we're going to get information that is going to change the needle that significantly in that way, based on the fact that we've been working on this for as long as we have, and we have the information we have, and we will have the information that we've requested again. And I just don't want to prejudge the situation now by not leaving the staff time to complete the rulemaking, because in my view, that would be a failure that we could be sued over. Mr. Laird.
I don't know if I have anything further to add then. I certainly appreciate the points raised. I hope also, as we've reviewed the SRIA and the economic impact, I can't help but mention there's also a benefits analysis that's included as well that, estimates job growth over time and increased revenue. So I recognize this is all very delicate, and the policy of this is certainly to the board, but there's a variety of factors at play that we've had to take into account, certainly at the staff level.
And also attend to this agenda item, we should be talking about scheduling a meeting.
That is a fine point.
And
Thank you.
these do go into the question of scheduling the meeting. But if it's talking about board resources, our own resources, finding time in July, I think we need to find the time, folks.
Are we talking?
Please,
Are we looking for Fridays?
We had a held date that we released, but we needed to release.
What number was it?
I don't know.
It was the 11th.
It was the 11th, and we released it because presumably somebody had a conflict. Or did we release it because we thought we wouldn't need it?
We didn't need it.
We wouldn't need it.
Okay, so how is the 11th?
We were wrong.
Yay! Take it.
What's that? Let's see. Well, I will say, the problem is we just held stuff for every month. I just can't have things held, I mean, for the purpose it makes sense, but I can offer you right now, we're talking Fridays only in July.
We're not,
No, we're
well,
not.
I'm not, because at least I can be more flexible outside.
Oh, that was
of
schools,
I don't know
okay.
about other folks, yeah.
Well, I mean, can I ask the other two, is there days of the week that are preferred? Because frankly, Friday's not the best, but.
That week, the first couple of weeks isn't great, so later on in July, I think is better for me.
But, how about 16 or 17? We're gonna have to give a few, and then I'll look at the next week.
That'll work for me.
16 or 17?
Yeah,
one board
that's
member
all
not
right
there.
for me. And of course, we'll need to find out if we have space.
I think the 17th works.
Then how about,
And we'll need to check with board member Nanaki.
how about 24 or 25?
Or 23, 24?
23, got another volunteer board meeting. So 24, 25, and someone remind me of the first two I already said.
Sam, do you think that's enough to work with? Or I'm mindful that board member Nanaki will need to weigh in, and sometimes people have, vacation plans.
I think that's something we can work with, and we are still looking for alternative locations too. So,
Okay.
yeah, Southern California.
There's a
in
decent
addition-
chance I'll be remote that one.
Yeah, and that works as long as we have we have a limited set of slots for which people can be remote. I wouldn't need to be remote, and if we have more than one location to work with, which I think we might have, that may open up options too, just in terms of making it more likely the dates would work for a venue.
Sorry, can you clarify? So two board members would already need to be remote with those days? Or
Just
depends on the
Mr.
city?
McTaggart.
Oh, okay.
And we don't know about Ms. Or Dr. Nanaki, yeah.
You said the 17th, 17, 23, 24?
17, 18, 24, 25.
It was 16
No.
16, 17, 18.
16, 17, and 24.
and 25.
And 25.
So, sorry, 16, 17, 24, 25?
Correct. So it's a Wednesday, Thursday, or a Thursday, Friday.
Okay.
And once you figure out where and what space, you'll let us know after talking to Dr.
Soon as
Naneki.
possible, yes.
Yeah, okay. Thank you.
All right, additional agenda items? Additional agenda items from the public?
Do we have any additional agenda items from the public? Please use the raise hand feature on Zoom or press *9 if you're calling in by phone. Madam Chair, I'm not seeing any hands raised.
Thank you very much. With that, we are, let's see, that was agenda item number 5. I'm now going to recall agenda item number 6, our closed session item on discussion and possible action on the appointment and employment of an executive director and chief privacy auditor under authority of Government Code Section 126 subdivision A1. The board will go into closed session now to discuss that item. We will return when we are finished to adjourn the meeting. Thank you very much, everybody. Wonderful. Welcome back, everyone. The board is now returning from closed session, and we will move to agenda item number 7, which is adjournment. It's our final item. I'd like to thank everybody, the board members, staff, who've been absolutely brilliant and incredible advisors today, and members of the public for all of the helpful comments today, for your contributions to the meeting and to the board's and the agency's work. May I have a motion to adjourn the meeting?
So moved.
Thank you. I have a motion from Mr. McTaggart and a second from Mr. Worth. We'll now vote on whether to approve the motion to adjourn. Ms. White, would you please conduct the vote?
Certainly. Board Member Liebert. Board Member McTaggart.
Aye.
Board Member Nonecki. Board Member Worth.
Aye.
Chair Urban.
Aye.
Madam Chair, you have 3 yeses and 2 non-votes.
Thank you. The motion to adjourn has been approved by a vote of 3-0. And this meeting of the California Privacy Protection Agency Board is hereby adjourned. Thanks very much, everyone.